Distinguished guests from all over the world participating in this ELI Decennial Celebration. Esteemed speakers, dear colleagues, dear friends. On the 1st of June 2011, so exactly 10 years ago, the European Law Institute was officially established as an international association under Belgian law by a royal decree of the King of Belgium. Also, on the 1st of June 2011, a magnificent inaugural congress was held in Paris at the premises of Paris 2 Panthéon-Assas, attended by hundreds of colleagues who shared one common vision: to create a platform for a more vigorous European legal community, a community of lawyers of all professions, judges, legal practitioners, academics, and many others, from across Europe and beyond, with the aim of debating important legal issues and raising their voices in an effort to improve the law or its application for the benefit of everyone. But of course, like Rome, the European Institute was not built in a day. For decades, there had been calls for an independent institution to play a similar role for Europe as the American Law Institute had played for the US since 1923. Especially from the 1980s onwards, these claimers became louder and louder. Spurred on by the success of the United Nations Convention on the International Sale of Goods, a whole series of projects were launched that attempted to formulate common European legal principles, such as the principles of European contract law, or later the draft Common Frame of Reference. All these efforts were clearly inspired by the famous restatements of the law of the American Law Institute. It became an era of enthusiasm for the idea of European restatements and European codification, and the vision of a European Law Institute was mostly that of an institution that would prepare and coordinate blueprints for European codification in the various traditional areas of the law, ranging from a European civil code to a European criminal code to a European code of administrative procedure. But why then did it take so long to actually establish the ELI? The reasons were many. 2 decades of striving for European codes had produced different groups, especially in academia, which cooperated with each other, but also competed with each other. There were also very different ideas about how a European Law Institute should be organized, in particular whether it should be a top-down or a bottom-up initiative, and whether to wait for stable funding and only then start working, or to start working right away, largely on the basis of volunteer work. It took until 2010 before it was possible to join forces, bring the different strands together, and agree on a roadmap. The way was paved by meetings convened in Hamburg by Reinhard Zimmermann, director of the Max Planck Institute, and in Vienna by Irmgard Gris, then president of the European Network of Supreme Court Presidents. And I'm particularly glad that both are present and will speak today. The final meeting of the ELI Founding Committee was held in Athens in April 2011 at the kind invitation of Spiridon Flogaitis, director of the European Public Law Organization. 2 members of the American Law Institute were closely involved, shared their experience, and provided immense help in the birth of the ELI. They were George Berman and, of course, the then ELI director Lance Liebman, and we are very honored that he has also agreed to speak to us today. However, it was not clear until the very last moment whether the founding convention would succeed or fail. I will never forget in my life the moment of relief when, after the final signing of the founding documents, everyone climbed the hill to the Temple of Poseidon at Cap Soignon at sunset to celebrate and share their joy and relief. What followed was the splendid founding congress organized by Bénédicte Fauvard-Cosson, now judge at the Conseil d'État, the election of the first leadership, in particular the founding president, Sir Francis Jacobs, and the decision on the seat of the ELI Secretariat. After a Europe-wide call for tenders, 3 state and non-state organizations made it to the final round. And it was the University of Vienna that finally won the bid, thanks to the extraordinary commitment of its rector, Heinz Engel. The ELI has since been grateful for and proud of this partnership with the University of Vienna, which has provided the stable framework for the ELI's work for a decade. What those gathered in Paris may not have fully realized is how much times were about to change. In 2011, the era of enthusiasm for major European restatements and ultimately European codifications in all traditional areas of the law was not so much taking up speed. It had almost come to a halt. Not even the common European sales law, as an optional European regime and much more limited in scope than earlier visions, proved politically feasible and was eventually dropped. By 2011, a new decade had begun, marked by a financial crisis, resurging nationalism that culminated in the UK leaving the Union, and the challenges of mass migration following the outbreak of war in Syria. But it was not only this political development that marked a new era. It was also the digital revolution. With some delay, the realization that laws developed for a largely analog world would not carry us through the 21st century took hold. And the search for legal rules that would meet the challenges of the digital age became a priority task for the legal community. This evolution is perfectly reflected in the ELI's work on the law of sales, which spanned a total of 6 years and illustrates the changes that were taking place. Immediately after the establishment of the Institute, and still in the spirit of the previous decade, the ELI began work on the proposed Common European Sales Law, alongside several projects in the field of public law. In 2012, a report of over 300 pages was published, containing a proposal for a complete redraft, and intended as a toolbox and source of inspiration for the EU institutions. And the EU institutions did use that toolbox. Not only did we have several high-level meetings with the European Commission, but an amazing part of what we drafted made it into the parliamentary work and was officially taken up during the legislative process. When the proposal was eventually withdrawn for political reasons, ELI did not give up. On the contrary, it closely followed developments at the EU level in several smaller reports. In the end, however, the most influential part of the work turned out to be draft legislation presented informally at ELI conferences in 2016 and finally at the annual conference in 2017, which is why essential elements of the new digitized consumer sales law in Europe can be traced back to ELI's work. This illustrates how the ELI had to adapt to the new need for more agile responses, more flexibility, and contributions that were sometimes more informal in nature. Of course, the ELI never abandoned its idea of creating major pieces of work that would serve as a permanent frame of reference for future work in the field. An example of this is the European Model Rules of Civil Procedure, which were developed together with UNIDROIT and involved large parts of the European scientific community. But we learned that impact can come in many guises. Sometimes it was work in progress that influenced European legal development, such as the ELI's report on rescue of business influenced the proposed restructuring directive. Sometimes the impact was not a direct one at the European level immediately. For example, the Principles for a Data Economy, a project carried out jointly with the American Law Institute, developed a typology for data transactions and a new concept of rights in code-generated data. This strongly influenced work first at the international level, including preparatory work done at UNCITRAL and the work of the Global Partnership on AI, which is supported by the OECD, as well as at the national level, such as work of the German Data Ethics Commission, which advises the German government. And it was then that those preparing the European data strategy contacted us and took on board ideas. The realization that impact can come in many forms and that sometimes more agile contributions are needed has led the ELI in recent years to introduce new types of output alongside ELI projects. These include so-called innovation papers, such as the innovation paper on making product liability fit for the digital age, and other types of output, such as the ELI principles for the COVID-19 crisis, which have been translated into several European languages and have generated very positive reactions across Europe. With these new forms of output, with 13 ELI projects completed, and with no less than 14 ongoing projects and more in the pipeline, the ELI's work has clearly picked up speed in recent years. In 2020, the European Law Institute defined 3 priority areas for its current work: the rule of law, law and governance for the digital age, and sustainable life in society. These focus areas coincide with at least 3 of the European Commission's priorities for 2019 to 2024, and with some of what I believe are the most pressing challenges of our times. Colleagues, ELI has not only survived these first 10 years, but has grown into a strong community of excellent members from across Europe and beyond, with a total of over 60 jurisdictions represented and a network of key institutional members, including the European Parliament, the European Court of Justice, international organizations such as UNCITRAL or UNIDROIT, professional associations such as CCBE and CNUE, and Supreme Courts such as the Conseil d'État, to name just a few of the institutions represented at today's celebration. Institutions and individuals from a wide variety of professional backgrounds, working in all areas of the law, with the vision of building one European legal community. A European legal community that will withstand the challenges of resurgent nationalism, attacks on the rule of law or democracy, and that will continue to be a reliable framework for cooperation and joint action even when cooperation at the political level has reached a dead end. Once again, welcome to this decennial celebration. And it is now my great pleasure to hand over to Reinhard Zimmermann, Director of the Hamburg Max Planck Institute, and more importantly, Speaker of the ELI Senate, and incredibly important in setting up this institution. Reinhard, the floor is yours.
Ms. President, dear Christiane, dear colleagues, ladies and gentlemen, thank you very much, Christiane, for your introduction. 99 years ago, in May 1922, a committee on the establishment of a permanent organization for the improvement of the law was founded in the United States. It was chaired by the former Secretary of State, Elio Root, and it produced a report on the basis of which the American Law Institute was established in February 1923. It will therefore soon celebrate its 100th anniversary. We are celebrating another, more humble anniversary today, 10 years of the European Law Institute. The European Law Institute is an independent, non-profit organization established to study and stimulate European legal development in a global context. Its mission is the quest for better lawmaking in Europe and the enhancement of the European legal integration. These aims certainly resonate with the aims of the American Law Institute, which were to promote the clarification and simplification of the law and its better adaptation to social needs, to secure the better administration of justice, and to encourage and carry on scholarly and scientific legal work. The example of the American Law Institute, I think, was always present in the minds of those involved in the setting up of the European Law Institute. But so were a number of differences concerning the challenges faced by both institutions, the differences in the case of the European Law Institute, for instance, of the national traditions, the difference of the languages, to mention just two of the challenges. The 10th anniversary provides an opportunity to look back at how it all started. Christiane has already touched upon it. A number of cities can be mentioned to indicate the milestones on the path towards the European Law Institute: Brussels, Florence, Hamburg, Vienna, Athens, and Paris. The events for which these city names stand took place between October 2008 and June 2011, and that is, I would say, a remarkably short period of time. Brussels, October 2008, was an important moment in the history of the Association for a European Law Institute. This was an initiative based on individual membership initiated by members of the Joint Network on Common Principles of European Contract Law. And within a very short period, it managed to attract more than 300 members. At the meeting in Brussels, the aims and types of projects to be carried out were specified. In April 2010, a conference took place in Florence under the title A European Law Institute Towards Innovation in European Legal Integration. It had been organized by the European University Institute. The invitees were representatives of a long list of networks active in one way or the other in the field of European private law. The contributions to this conference revealed a widespread agreement that the creation of a European Law Institute would be highly desirable. What was not, however, regarded as highly desirable was the creation of two competing European law institutes. This is why in Hamburg in June 2010, a mediation effort was made to bring these two initiatives together. And indeed, as a result of the meeting in Hamburg, a joint roadmap was agreed upon. And if one reads the Hamburg Memorandum setting out the details of this roadmap, one is surprised to see how many of the characteristic features of the European Law Institute, as eventually established, were already contained in it. No limitation to private law. No, it was not supposed to replace existing networks and organizations. The principle of independence, the idea of individual membership. Even small things like membership fees were discussed, transparency of proceedings, and even the general meeting constituting the ELI in 2011 was already envisaged. At first, however, a joint project group was established, which met in November 2010 in Vienna. At that meeting, the purposes and tasks of the European Law Institute were specified, and the founding committee and 3 working groups were set up. These 3 working groups were set up in order, 1, to prepare the draft manifesto and the draft statute, 2, to deal with organizational issues, and 3, to deal with the type of projects to be embarked upon. The founding committee met in April 2011 in Athens. The drafts of the 3 working groups were discussed and agreed upon, much else was agreed upon, and ultimately the decision was taken to found the European Law Institute as an association internationale sans but lucratif under Belgian law. There's a picture of the founding members below the ruins of Poseidon's temple at Cape Sunion. Cape Sunion, of course, being a holy place, according to Homer, and a place where one is supposed to pray for a safe journey. Now that journey took us 2 months later to a place whose coat of arms says, fluctuat nec mergitur. It may be tossed by the waves, but does not sink. Now that place does not exactly lie at the coast, not like Cape Sunion or Athens, it is Paris. And so on the 1st of June 2011, the European Law Institute was officially opened with, Christiane has said that, a really splendid inaugural Congress. Splendid as that inaugural Congress was, the European Law Institute at that stage was still a rather modest organization. There were 52 persons as founding members, and there were 4 founding institutional members. Well, we have come a long way since then. Today, the European Law Institute has 1,542 individual members and 115 institutional members. And it has done its best to implement the 3 great diversities mentioned in all the memoranda since the Hamburg Memorandum, in the inaugural address delivered in Paris, and 3 divergences which are very much in line with the motto of the EU, in varietate concordia, united in diversity. Diversity of backgrounds. We have members from 62 nationalities, originally only 22. Diversity of disciplines. Just about every area of the law is covered by the European Law Institute, including, on the very general side, philosophy of law, and on the other hand, the specialized branches such as medical law and transplantation law. And then, of course, diversity of professions. Well, just over half of the members are still academics today. But the number of practicing lawyers, judges, regulators, notary, government officials has steadily grown. And if I look at the 7 members of the first executive committee, they came from England, France, Austria, Italy, Greece, Sweden, and Bulgaria. They included 4 academics and 3 legal practitioners, 4 men and 3 women. And I might actually say that women have played a very important role in the running of the European Law Institute over the past 10 years. 13 projects have been completed, including a critical examination of the proposal for a common European sales law. That was right at the beginning, including also model rules of civil procedure. I mentioned that because it was a project done together with UNIDROIT. 14 projects are going on at the moment. A number of them relating to law and governments for the digital age, a topic also of particular importance for the European Commission if you think of the digital market strategy for Europe. The ELI has 12 hubs and 11 SIGs, hubs being country-specific groups, 6 special interest groups being topic-specific groups. A Young Lawyers Award has been created. A book series has been launched with a prominent English publisher. Regular newsletters are being published in order to inform members and the general public about what is going on. An annual activity report is being published. And a cooperation has been established with organizations such as UNIDROIT and the American Law Institute. The principles for data economy have been mentioned. The annual General Assembly takes place every other year in Vienna, in the years in between, in cities around Europe. So far, if I remember correctly, Brussels, Zagreb, Ferrara, and Riga. Much more could be mentioned. That all this has been possible is due to the efforts of dedicated and enthusiastic persons who have taken an active part in the General Assemblies. That's the general directional body in terms of the Articles of Association, who have served on the administrative and executive bodies of the ELI, the Council and the Executive Committee, and who have been part of the project teams, the advisory committees, and the members' consultative committees. On behalf of the members of the Senate of the European Law Institute, I would like to thank all those persons very sincerely and to congratulate them on what has been achieved. The European Law Institute is firmly rooted within the European Union. The nationalities of the members shows that. Italy, Germany, Spain, Austria being at the head. But the European Union is not existing in isolation, nor are its legal systems existing within isolation. Spanish, Italian, and Portuguese law have impacted in large part, have an impact in large parts of Latin America. French law in Quebec and Louisiana and parts of Africa. German law in Japan and Korea. Dutch law in South Africa. More examples could be cited. Also, even after Brexit, we should always remember that Great Britain has historically been part of Europe and part of a European legal tradition. And English lawyers have rendered sterling services to the European Law Institute over the past 10 years. And I would like to emphasize that we cannot do without the experiences of the common law, and of course also of the fascinating mixed legal system of Scotland. The English common law is our bridge to the common laws prevailing in large parts of the world, and I think it is part of the European Law Institute's mission to keep these links alive even in adverse political situations. And also, of course, to foster the links to other parts of the world. And so I'm very pleased that we have members from South Africa and Nigeria, Iran, Pakistan, India, Peru, Colombia, Russia, Ukraine, 62 nations, as I've mentioned. And I think the ELI will continue to draw its strength from the diversity of its sources, but it will remain firmly committed to the values inherent in the European tradition, including civil law and common law, and a core value in that regard is particularly the rule of law. None of us, presumably, will be present when the European Law Institute celebrates its 100th anniversary. But many of us, I hope, will be there in 15 years when the European Law Institute turns 25. I think after what has been achieved, we can look forward with confidence to that event. Thank you very much.
Well, thank you so much, Reinhard. And in fact, thank you so much to the Senate. The Senate has been incredibly important in setting up the ELI, in running the ELI. So thank you so much for everything you have done. And we are really looking forward to the 25th year anniversary. But before we can celebrate that, I'm afraid quite some work is lying ahead of us. It is now my honor to announce the welcome address by Vera Jourova. She is Vice President of the European Commission for Values and Transparency, and she deals with topics such as democracy, rule of law, disinformation, and media pluralism. From 2014 to 2019, she served as EU Commissioner for Justice, Consumers, and Gender Equality. And already in that position, she has been a strong supporter of the ELI for years, and she would have loved to be with us in person today. But it turned out that the 1st of June is a very popular date for opening new institutions. So unfortunately, the European Public Prosecutor's Office starts operating today, requiring her presence. So we are very grateful to her for having sent us a video message instead.
Dear European Law Institute, happy anniversary. Your institution has contributed so much to fostering a genuine and vigorous European legal community. From developing the area of cross-border judicial cooperation to enhancing consumer rights, from making advancements in private international law to more recently bringing light into the rolling out of artificial intelligence. These are only a few of the many topics on which you contributed to the work of the European Commission and ultimately to better lawmaking. I'd like to thank you for all your work of the highest professional standards and for always taking a pan-European perspective. Dear distinguished guests, the European Union is built on our shared values and respect for our diversity, including our diverse legal traditions. These values and traditions are at the heart of our democracies, and as Vice President for Values and Transparency, they lie at the heart of my work in the Commission. This is why allow me to give a brief picture on the state of our democracies, pointing to some challenges we face and the mission ahead of us. The digital revolution has brought new opportunities, but also challenges. More and more citizens are getting their information and engaging in the democratic process online, which makes outreach easier. But it is difficult to uphold fundamental rights and democracy in a largely unregulated online space, especially when the business models of social media platforms do not always encourage free and open debate. Polarizing messages and unreliable information can limit perspectives and hamper the ability to make informed decisions, which has a dangerous effect on our democratic societies. Europe wants to go digital, but we want to do it in our truly European way, in full respect of our fundamental principles. Furthermore, the COVID pandemic crisis also posed challenges for democratic processes, freedom of expression, and pluralistic debate. It showed us how vulnerable we are to interference. Disinformation has been particularly acute during the pandemic. We have also seen how important it is to uphold our fundamental rights and values and to maintain and adapt democratic checks and balances. As we hopefully gradually emerge from this crisis, we need to go back to full restoration of citizens' rights and normal functioning of institutions. But we also need to learn from the lessons of this crisis. We need to make our societies more resilient and better prepared for future, including by improving access to justice through digitalization. We need our democracies to be more resistant to the spread of disinformation. And we need to help those affected the most by this crisis, especially the vulnerable groups. The crisis has also put added strain on media across Europe. Economic hardship, restrictive emergency measures, and personal attacks on journalists are reducing the space for a free and fair debate grounded in facts and good reporting. A healthy democracy relies on citizen engagement, an active civil society, and media actors to play their watchdog role. This is why the European Democracy Action Plan includes measures to strengthen media freedom and pluralism, alongside measures targeted to fight disinformation and ensure free and fair elections. We are now in full swing to prepare the various initiatives included in this plan, and I invite you all to contribute throughout the process. But in order to make advancements, our democracies need also researchers and academic freedom. Work such as the new ELI project on freedom of expression as a common constitutional tradition in Europe is much welcome, as it could make a great contribution to addressing some of the challenges to our democratic space. We also need to work together to defend the rule of law. This is the very foundation without which citizens' rights cannot be guaranteed, without which our European judicial cooperation cannot operate on the basis of mutual trust, and without which our internal market cannot go deeper. Defending the rule of law is not a task for a lonely sheriff, be it at EU or national level. It is a task for all of us, be it our institutional roles or just in our daily citizens' life. In the EU, we have developed further our rule of law toolbox, and we will deploy it, be it on the preventive side or to correct deficiencies. The Commission is ready to play its part, but democracy belongs to all of us, and as such it can only be lived and defended by all of us. That is why many of these problems will need a whole society approach and international cooperation in a coordinated effort of governments, judiciary, civil society, researchers, media, the business environment, and citizens themselves. We have a good story to tell in the EU about democracy and our values. Let's work together to build this story further. Thank you for your attention, and I wish you fruitful discussions.
Well, thank you so much again to Vice President Jourova. It is now my great pleasure to announce our next speaker, Lance Liebman. Lance is the William S. Beinecke Professor of Law Emeritus and Dean Emeritus at Columbia Law School. From 1999 to 2014, he was Director of the American Law Institute. And it was in this position that he provided incredible assistance and invaluable guidance to the founders of the European Law Institute. We have a very strong relationship with the ELI ever since, and we just successfully completed a joint project under its current director, Richard Reves. Lance, thank you so much for being with us today on this occasion and for addressing our audience.
Thank you, Christian. That was a little bit of an exaggerated introduction, but I appreciate it. President Lyndon Johnson years ago, when somebody introduced him too much, he would say, "Oh, that was a great introduction. My father would have loved it and my mother would have believed it." But this is a little bit the same. Okay, so the three talks we have heard are very special and include an amazing part of the 10-year great ELI story, and were very serious talks. Mine will be shorter and less serious. But let me just say that I'm in a very happy mode at the moment. And this is because in an accident of how things work out in one's life, on June 30th of 2019, I retired after 50 years as a professor of law at Harvard and Columbia, and of course 15 years running the American Law Institute. I retired, and I was going to have a new life, and then all of a sudden came the pandemic that all of you were affected by and know about. And so it's now been more than a year, of course, like with many others of you, that I've been locked up at home and staying healthy and whatever. But we're now, over here in New York at least, coming a little bit out of this. And that's why I'm saying I'm happy. I'm happy because on the weekend, one of our grandchildren was able actually to sleep in our apartment with us overnight. And that hadn't happened in a year. When Sal walked in, he said, "I haven't been in this apartment for a year in our place," even though he lives a mile and a half away from us. So that's great. Also, on Saturday, we went to a restaurant for the first time in more than a year, a very nice restaurant with very good friends. And that's a step in a certain direction. And then this opportunity for the European Law Institute is also a very happy occasion, in part because I think so well and have worked so well with Christian, but also because on the program here is Koen Lennertz, whom all of you know, who was definitely one of my favorite students in my 50 years of teaching, favorite law students. Okay. Now, let me say also that I did have happy times at the American Law Institute. The ALI, and this applies at the ELI too, and the experience of ELI leaders confirms this, there's so many different subjects being taken up. The ALI would always have 15 or 18 projects. I would know a lot about maybe one or two of those subjects, but of many of them, I didn't know a lot. And I would sit in front running a meeting, and then I was told about one of my predecessors as director of the ALI, I won't give his name, that predecessor could be visibly fast asleep in front of the room leading the meeting, and then suddenly wake up and ask a brilliant question. And I had said, well, I've got the first half of that worked out. And I tried not to fall asleep in front, but sometimes I did. I will say that running the ELI from New York, an organization that's, the ELI is in Philadelphia, running it from New York had an advantage, which is I didn't have to dress up very much. I did my work on the telephone. They didn't have Zoom then, and stayed in touch with all these reporters, academics, professors, lawyers, judges around the United States and some in other countries. And I would work on that, but I only had to go to the meeting for maybe 2 days a week. And indeed, one of my reforms at the American Law Institute was to say that men did not have to wear a tie if the meeting was on Saturday. And here I'm not wearing a tie, and the meeting is on Tuesday. I also made a change in policy to not have any alcohol at lunch. We would drink wine or whiskey or whatever at dinner, but not at lunch. And that helped in terms of how many people would fall asleep in the meeting. Okay, now I'm going to talk about the European Law Institute. As you heard earlier, the ELI was founded in 1923. The first director, William Draper Lewis, was a professor and I think the dean at one point of the University of Pennsylvania School of Law. He had a rich wife in 1923, and she put up the money to start the ELI, and that's why it's located in Philadelphia, where William Draper Lewis became the first director, the job I had 75 years, 80 years later. And his wife paid some of the early bills, then various foundations contributed, etc., and this got off the ground. The core of the ELI was the need of the United States with 50 states to try to coordinate common law, the American and English phenomenon, and also to come up with statutory recommendations that were very much needed. I first heard of the ELI, the American Law Institute, in my first year of teaching when one of my teachers, a very serious and imperfect person named A. James Kasner, we as students used to call him the James Kasner, which is how he thought of himself. And he had a dinner for some ELI people who were meeting in Boston. I was at Harvard. And it was an amazing moment. My wife, young wife, was, now my wife of 60 years, was there with me at this dinner. And Jim Kasner went around the room and said to each of the males in the room, asked nothing of did not give the women a moment to speak, but asked each of the men, would you tell me when you met me and why I'm important to you? And that was an experience I've tried hard not to duplicate in my own life. In any case, as you heard earlier, it became the 1980s, the 1990s, and people in Europe had very good reason to think of a law coordination organization and put on a bunch of meetings all in wonderful places like Florence, Vienna, Paris, other places. And for almost every one of those meetings to try to discuss having an ELI, they invited me to come over and to explain about the ELI. Well, that was wonderful. And Carol and I usually could come together, and it was great to be in any of these places and whatever. So I was rooting pretty hard that the ELI not get founded, because I wanted to be more of these exploratory meetings that I could come to. But you couldn't stop it, and people became convinced, and the ELI was founded, and I was at that great founding event in Paris. There were other founding events. As was mentioned, George Berman was at the one in Greece. And of course, the ELI was happy to try to help. And I was very happy to come to the in-person annual meetings every other year in Vienna, and then in between at places I had otherwise not known. For instance, it was interesting to be in Riga. So I very much look forward to the pandemic being over and the meetings being in person again. Now, let me say as a final point that since I'm reporting happy things, here is my final happy thing. At the ALI's annual meeting of the year was split. It's online, of course, not in person, and so there were 2 days of meetings on Zoom 2 weeks ago, and then next week are the final 2 days. So they're trying to finish 4 of their projects or our projects, and trying to keep about 15 other projects on the move. Last week, 2 weeks ago, at the ALI annual meeting, the great work of Christian Venderhorst and Lord John Thomas, along with the American leaders of the project, on the vital and brand new subject of data, received unanimous approval at the ALI. And so now it's ELI's turn to approve. And then the 2 organizations will have achieved their first cooperative work, and I'm quite sure ready to think of other areas of law in which we can work together. So I am thrilled to have been invited for this, and I know the rest of the meeting is going to be much more serious than anything I've just said. Thank you.
Well, Christiane has asked me to take over from her because she is preparing already the panel discussion afterwards. So thank you very much, Lance, for your inspiring talk. It is wonderful to have you with us, even though it's only via Zoom. And I think we are all looking very much forward to having you with us again at the next annual general meeting in person. Thank you very much for your talk. Thank you very much for all your assistance and advice in the background and at the various meetings that you have mentioned. And I think the fact that you have been here today with us and that you have spoken in the way in which you did is highly symbolic of the excellent relationship that we have developed between the European Law Institute and the American Law Institute, and from which we certainly have benefited so much. Thank you very much. It is now my pleasure to announce something very special, the European anthem. Now, you all probably know that the European anthem is the Ode to Joy by Ludwig van Beethoven, whose 250th anniversary we celebrated last year. And the European anthem is one of the official symbols, actually, of the European Union. It will be performed by the European Union Youth Orchestra. That youth orchestra was founded in 1976 by inter alia Claudio Abbado and Sir Edward Heath. And its mission is to represent the European idea of working together to achieve peace and social understanding. Before the young people will start to play the Ode to Joy, there will be a message by the Secretary General of the European Union Youth Orchestra, Marshall Marcus.
As Secretary General of the European Union Youth Orchestra, I'm delighted to add my welcome to all the honoured guests in the audience at this decennial celebration of the ELI. Congratulations on your 10th anniversary and for all that you've achieved in the field of European legal development. Like the ELI, the European Union Youth Orchestra is dedicated to advancing the case for European integration, for the huge advantages of working together, of the simple yet profound fact that we're better together. Yet there is more to the synergy between our organisations. The mission of the EUIO as cultural ambassador for the European project is to bring together the most talented young musicians from all EU member states in a diverse orchestra united by a shared sense of European heritage, innovation, sustainability, and the constant pursuit of excellence. Mission statements can often seem rather cold. And so in another way, our aims are not so different from you, to touch and to improve people's lives across Europe, but always with a pan-European purview. Now, it may seem strange, but lawyers and performing musicians come from exactly the same school and use exactly the same techniques. What was known in ancient Greece as the practice of rhetoric, the art of persuasion. So, without further ado, I'd like to introduce our first contribution to your celebration, a performance of the European hymn, the Ode to Joy by Beethoven, recorded last October at our summer home in Grafenegg on the exact day of the 75th anniversary of the creation of the United Nations, another great transnational example of being better together. That somehow seems appropriate. Welcome to this 10th anniversary event.
Colleagues, friends, ladies and gentlemen, it's now my great honor to welcome speakers of our first decennial panel discussion on the topic of facing the current challenges in Europe, the role of the institutions and civil society. We have a very distinguished panel, and it's hardly necessary to introduce them, but let me say a very warm welcome to Koen Leenaerts, President of the Court of Justice of the European Union, to Robert Spano, President of the European Court of Human Rights, Didier Reynders, European Commissioner for Justice, Adrian Vasquez Lazara, Chair of the European Parliament's Committee on Legal Affairs, and last but not least, Margarethe von Galen, President of the CCB. So a very, very warm welcome, and thank you so much for having taken the time to join us for our celebration of 10 years of ELI's contribution. And if you permit, I would like to start with you, President Leenaerts. Dear Koen, you're President of the Court of Justice of the European Union, and you have closely followed and always supported the work of the ELI, so thank you very much for that. And I would like to start with the question, what in your view are the main challenges which Europe is facing today, and what is the role of European and national courts in addressing those main challenges?
Thank you, President Venderhorst, dear Christiane, Excellencies, distinguished panelists, ladies and gentlemen. Let me first say it is a great honor and a pleasure for me to participate in today's celebration of the European Law Institute's 10th anniversary. I'm delighted to discuss today with you the role of the institutions and of civil society in facing current challenges in Europe. But before delving into the subject, I would like to congratulate you, President Venderhorst, and the Vice Presidents Thomas and Pikonas, the University of Vienna, which hosts ELI's Secretariat, as well as the entire ELI membership for the outstanding achievements over the past 10 years. ELI's purpose is to develop and improve European law. It does so by conducting research projects, authoring publications and policy briefings, and by preparing draft laws. ELI's reputation as a center of excellence is incomparable. It fills me therefore with pride that the Court of Justice of the European Union, as an institutional member, has recently been involved in a project of ELI on the constitutional traditions common to the member states, a notion first referred to by the Court of Justice in the famous case Internationale Handelsgesellschaft, a concept which is now enshrined in Article 6, paragraph 3 of the Treaty on the European Union and in Article 52, fourth paragraph of the Charter of Fundamental Rights of the European Union. the Research and Documentation Directorate of the Court of Justice of the European Union, which is our own comparative law laboratory, is pleased to contribute to this project's success by sharing its insights in this field with ELI. At present, the world is facing an unprecedented pandemic. Its long-term effects will put enormous pressure on the functioning of states, their national economies, democratic institutions, and judicial systems. At the same time, societal, technological, and environmental change, as well as political polarization, put social cohesion at risk, not only in Europe, but around the globe. One of the major challenges that the European project in general and the Court of Justice of the European Union in particular are currently facing is a challenge to uphold the common value of the rule of law. Please allow me to illustrate that challenge by looking briefly on what I would call the contextual approach that the Court of Justice has applied in its case law concerning the rule of law within the EU, and in particular, the case law with respect to the duty of the member states to respect the principle of judicial independence. In its landmark judgment of February 2018, Associação Sindical dos Juízes Portugueses, the Court of Justice made explicit the premise on which the entire EU system of judicial protection is built, namely that national courts, as the courts of general jurisdiction of the European Union, must remain independent. It ruled that the member states must ensure that any of their courts, which may be called upon to apply EU law, meet the requirements essential to effective judicial protection, of which the principle of judicial independence is one, possibly the principal one. This is because without judicial independence, no effective judicial protection may be provided, nor may the uniform interpretation and application of EU law be guaranteed. Since the principle of judicial independence is an essential component of the EU system of judicial protection under Article 19 of the Treaty on the European Union, and of the fundamental right to effective judicial protection enshrined in Article 47 of the Charter of Fundamental Rights of the European Union, it is for the Court of Justice to determine, in the fields covered by EU law, its meaning and its scope. The principle of judicial independence is thus an autonomous concept of EU law, drawing, however, on the constitutional traditions common to the member states. In this respect, it is worth pointing out that the Court of Justice does not seek to redesign national judiciaries, since the organization of justice in the member states clearly falls within the competence of those member states. The rule of law within the EU is not one rule to rule them all. It allows room for diversity and does not militate in favor of a specific constitutional model, but limits itself to providing a framework of reference intended to guarantee the uniform application of EU law and to protect the values on which the EU is founded, values laid down in Article 2 of the Treaty on the European Union. Within that framework of reference, member states are free to choose different rules regarding the appointment and the length of service of judges, the grounds for abstention and rejection, and to adopt different disciplinary regimes. But that being said, the Court of Justice nevertheless held in commission against Poland independence of the Supreme Court, in which it found that the lowering of the retirement age of judges of the Supreme Court was contrary to EU law, that, I quote, "The fact remains that when exercising their competence to organize their judiciary, the member states are required to comply with their obligations deriving from EU law." Accordingly, the Court of Justice examines whether national rules on the organization of justice comply with the indispensable requirements of the rule of law, such as the principle of judicial independence. Those rules, that is, the national procedural rules, are thus circumscribed by a common rule of law understanding and must be such as to dispel any reasonable doubt in the minds of individuals as to the imperviousness of the judicial body in question to external factors and its neutrality with respect to the interests before it. In order to determine whether such rules dispel those doubts, the Court of Justice held in its AK judgment of 2019 concerning the independence of the disciplinary chamber of the Polish Supreme Court that it must not only examine their normative content, but also the reasons behind their adoption and the way they are applied. It follows that the Court of Justice relies on an overall assessment of all relevant factors in law and in fact. Whilst one factor may not suffice in itself to call into question the principle of judicial independence, that factor taken together with other factors and considered in the light of the circumstances surrounding them may throw doubt on the independence of the national judicial body in question. Such assessment of the specific national legal and factual context implies that the national rule governing the organization of justice, for example, a rule on the appointment of judges, may be incompatible with the principle of judicial independence as interpreted by the Court of Justice in that specific national context. However, that same rule may be harmless in a different national context. That is why all these judgments are very much context related. Thus, only 1 month ago, the Court of Justice found in its Republika judgment that the requirements of judicial independence do not necessarily mean that the Prime Minister of a member state, in this case Malta, should not have a decisive power in the process for appointing members of the judiciary. Such a power may perfectly be permissible, as was the case in the Maltese context, where an independent body is involved in the process of appointment, which is tasked in particular with assessing candidates for judicial office and providing an opinion to the Prime Minister. A similar content-sensitive approach can be found in the case law of the European Court of Human Rights in Strasbourg. Both the Strasbourg and the Luxembourg courts thus carry out, in each case in which the independence of a judicial body is questioned, a detailed assessment of the judicial independence's de jure and de facto components in the legal system concerned. To conclude, I can only welcome the recent ELI project on European standards of judicial independence, launched in April of this year, I quote, with a view to provide guidance on this fundamental aspect of ensuring democracy and respect for the rule of law in times where these values are put to the test, end of quote. This project underlines once more the importance of the joint endeavor of the key institutions of the European legal landscape and of ELI as voice of the European legal civil society to address effectively the challenges of today and tomorrow, such as the current challenges to judicial independence and the rule of law in Europe. That may suffice as an initial statement, and I'm thanking you.
Well, thank you so much, Koen, for this really encouraging statement of yours, and thank you so much for all your support. I think it was extremely helpful for our audience that you explained to us once more this really important part of recent case law of the Court of Justice. And speaking of the audience, I would like to encourage the audience to make use of the Q&A function, because we will have a short Q&A after this first round of statements. So please do choose the Q&A function, type in your questions to the panelists, and we will try to address them. But let me turn now to President Spano. Strasbourg has already been mentioned. You are president of the European Court of Human Rights, and as you know, the ELI has a long-standing connection and relationship also with your court. I don't know whether you know that the first ELI project ever was on the case overload at the European Court of Human Rights. So we started our work, in fact, with a project on the European Court of Human Rights. And President Lehnaert has already addressed some very, very important points: the rule of law, the independence of the judiciary, also, of course, the subsidiarity principles that is inherent in the ECHR feature system. So what is your take on these challenges which Europe faces at the moment, and what is the reply from the European Court of Human Rights?
Well, let me begin, like my good friend President Lenners, to also thank ELI and you, President Wendehorst, for inviting me to take part today in this debate, which is crucial. It is extremely important that we continue to share experiences and also reflect on how our different institutions, potentially with different roles, can play a part in creating a landscape of understanding and a landscape of an awareness. It is indeed the case, as you mentioned, that ELI was founded to create a European legal community of academics, practicing lawyers and judges, and I consider that this achievement is actually one of the fundamentals for us to engage with the challenges we are facing at the institutional level. Now, firstly, what are these challenges? One of the most important European challenges currently facing us is what the Secretary General of the Council of Europe has in a recent, very important report called democratic backsliding. This is evidenced by litigation before the Strasbourg and Luxembourg courts, as mentioned by President Lenners, on key rule of law principles, and in particular, judicial independence. However, let's not forget there are other crucial challenges with which European societies are facing, including climate change, developments in technology, and societal changes such as backsliding against women's rights and the rights of the LGBTI community. This brings me to my next question. What role can be played by the wider legal community? I would like to begin answering this question by referring to, as you mentioned, indeed, the principle of subsidiarity, which is, and to be very clear for the audience, this is a different principle to the principle under EU law of subsidiarity, because this is an institutional concept relating to the positioning of the Strasbourg court vis-a-vis the national authorities. It is not the decision-making concept under EU law, which is a different one. So I just want to make that clear so all in listening understand what I'm going to describe. Now, this principle is implicit in the structure of the European Convention on Human Rights. And indeed, from August 1st of this year, only in a couple of months, Protocol 15 to the European Convention on Human Rights will come into force. A new recital will be added to the end of the preamble to the convention, containing a reference to the principle of subsidiarity and the doctrine of the margin of appreciation. For Strasbourg enthusiasts, it's important to realize that these concepts are as such not in the current texts of the body of convention law. Subsidiarity encapsulates a norm of the distribution of labor between the Strasbourg Court and the Council of Europe member states, with the ultimate aim of securing to every person within the jurisdiction of a state the rights and freedoms under the convention. The core part, and it's here where I come into this discussion along with President Lenaerts, it is that subsidiarity is not realistic without strong, independent, and impartial domestic courts embedded within a national system that is governed by the rule of law. One might say that doctrinally, the principle of subsidiarity, as encapsulated in Article 13, the provision requiring an effective domestic remedy, and Article 35 requiring only the exhaustion of effective domestic remedies, is our structural norms, which are synonymous to this extent with Article 19 of TEU. So that is the reason by which, in the famous Portuguese judge's case, the fundamental core explication of the principle of judicial effectiveness under Article 19 TEU in paragraph 35 of that judgment is interrelated to the principles under Article 13 and 35 and the principle of subsidiarity of the European Convention on Human Rights. So these are very much synonymous concepts, which again allow us to move forward in a manner of convergence, which we are at the moment. And this is one of the big challenges we are facing, but also one of our perennial duties, that is to create an element of legal certainty in the interrelation between the two courts. I would like to say, however, that the European community, and I also, because we have Didier Reinders, our colleague from Spain, and also advocates here, the European community is not limited to judges. We need effective national implementation between the interaction of all of the stakeholders. This in particular means members of government, public officials, parliamentarians, judges and prosecutors, as well as national human rights institutions, civil society, universities, training institutions, and representatives of the legal profession. This is a holistic endeavor where each of us must realize the importance of our roles. And again, and I said this before, a true human rights culture, and I say this, and I have to say this because it's part of what I think the president of the European Court of Human Rights must disseminate, a human rights culture at the heart of European law. Let's be very frank, it cannot be sustained in the long run by the top-down imposition of legal norms that do not resonate in contemporary societies. This is why it is essential to create this pervasive rule of law and human rights culture with legal practitioners and civil society, as well as with citizens. And this is where I think ELI can make a great difference. And this allows me then to move to my conclusion, which is to come again to the convergence rationale and the immense importance of President Lenaerts' explication of the contextual approach. Because what does the contextual approach do? And I believe that also the European Court of Human Rights, with its ex post facto control, which is direct review control, has to engage through the principle of subsidiarity in the classic contextual type assessment. But what does, as a matter of narrative, what does a contextual approach do? It makes clear that even though I myself in the Strasbourg court and Koen Lenaerts in Luxembourg are presiding international or let's supranational courts, we are speaking to the populace, and it is for them to integrate these principles in a manner which resonates with their constitutional traditions. This is not a means of absolute harmonization and unification. It is unity and diversity. This is the concept which I also very much share with President Lenaerts. Let me then conclude by saying that I am very hopeful. I'm very hopeful that the continuing debate of this sort will provide meaningful and create meaningful awareness for all of the different stakeholders. And I'm very, very happy to be a part of the debate here today. And I look forward to the questions that will come as we continue our debate. Thank you very much indeed, President Wendhorst.
Well, thank you so much, President Spano. I saw President Leenaerts nodding while you were speaking, so I took it that he agrees with everything you said. And I found it particularly important that you stressed this human rights culture and this rule of law culture, because it's really what we need. It's not about just letters on paper, it's about culture, and we need to live it. And if we don't live it, then it's not worth so much. So thank you so much for that. And let me turn now to the Commissioner for Justice, Didier Reynders. Commissioner, a very special thanks to you for joining us today. I know it was a very difficult date for you. You were in Luxembourg today. Thank you so much for rushing back to Brussels to be here with us today. And thank you so much for all the support you've already given to the ELI. When I remember our talks in the past, they were a lot about rule of law and the rule of law toolbox. So it would be interesting, I think, for our audience to hear your view of the role of this toolbox and the role it will play in the future. And also, what is the role of institutions representing the civil society and more specifically, of course, the legal community? So, Commissioner, would be very important for our audience to hear your view.
No, thank you very much, and thank you very much, first of all, Madam President, for inviting me to celebrate with you the Institute's 10 years, because it was a fruitful and cooperation on European legal policy making, and I'm sure that we'll continue to do that. And it's a solid and promising basis for our future cooperation. I know I can continue to count on the European Law Institute support for the European Commission, because, like you said, we have had some conversations before, but also we have taken advantage of some projects of ELI, and maybe also we'll do the same in the future. It's also a pleasure, of course, for me to take part in such a panel today, because we are speaking about one of the most crucial topics in the European Union, the rule of law. And I want also to thank the two presidents, Leenaerts and Spano, for their inspiring presentations about the rule of law, about the judicial independence, human rights. And I want to say quite the same about the one thing, because we are working now with a new toolbox for a part, like you said, with a new annual report on the rule of law. And the most important priority in this respect is to create, again, awareness to promote a rule of law culture among European citizens, not just to speak about the rule of law before the two courts in Strasbourg and in Luxembourg, not only in the three institutions at the EU level, in the Commission, the Council and the Parliament, but to go to the national parliaments, to go to the civil society, and to try to install a real culture of the rule of law. 2 weeks ago, I hosted, together with the Portuguese presidency of the Council, the first high-level conference on the rule of law in Europe. This conference in Canberra allowed for a broad exchange between, again, many key actors for the rule of law, such, of course, as judges, but also journalists, civil society organizations, politicians, and academics, of course, including the two presidents of the two courts from Luxembourg and Strasbourg again. At the same time, we need to protect the rule of law from concrete risks of violations. And it's true that we have seen some negative evolutions in Europe in the last years. And since the beginning of my mandate, I have insisted time and again that there can be no compromise when it comes to defending our common values. The Commission is, you know, the guardian of the treaties. This is why, since the beginning of its mandate, this Commission has already twice seized the European Court of Justice with a request for interim measures where we saw the risk of irreparable damage to judicial independence in Poland. to give one example explained before by the President Leonard, because it's true that we are very concerned by the evolution about the judicial independence in different places, but certainly with such a kind of situation in Poland. Another important challenge has been the COVID-19 pandemic. It has led member states to adopt emergency measures. Here again, the Commission has early on been vigilant that such measures do not go beyond what is proportionate and necessary. This work is still ongoing. Ultimately, what we are protecting here is individual freedom. And it's very strange because at the beginning we've started our monitoring and we didn't see so many reactions. But after more than 1 year, now we have seen that there are more and more people aware about their fundamental rights due to the limitation decided and the restrictions decided in the first lockdown, in the second wave of the pandemic. And now there are many reactions against that. And it's very important to have an oversight on all those measures, not only by the Commission, by the national parliament, but also by the independent justice systems in all the member states. But again, we need to do more, and I want to say that I'm very pleased to be engaged in such a way to use a very large toolbox at the EU level on the rule of law. For the Commission, we have different tools at our disposal. I want just to explain maybe some part of this. The Commission's new rule of law report that I mentioned, which it's a very important part because it's at the center of an annual European rule of law mechanism. It's become to be a cycle. It's new, aiming at detecting challenges to the rule of law before they emerge or deepen. The mechanism provides a process for stimulating yearly discussions on the situation of the rule of law across the European Union. At national level and not only at the European level, it was possible to do that on the same basis for all the member states, on an equal footing for the 27 member states. And of course, if it's possible to engage some best practices, it's also important to exchange the best practices among the member states. And for the second annual report to be adopted in July this year, I'm encouraging a consolidated and deeper assessment and a wider dialogue. In particular, we will follow up on the challenges identified again in the first report and on the consequence of the COVID-19 pandemic. Promoting it and upholding the rule of law needs to be an inclusive and not a top-down process. And this is why you spoke about the civil society. We recently concluded the virtual country visits, because during the pandemic it was all the time virtual, which include over 400 meetings with national authorities, courts, independent bodies and stakeholders. It will be important to make the best use of this report as a basis for a genuine dialogue on the rule of law with a wide variety of actors. In this respect, engaging with parliaments is a priority for me, and I have had a discussion with the Parliamentary Assembly of the Council of Europe in Strasbourg, but I have also a discussion with the European Parliament and with 20 national parliaments about the rule of law, the first rule of law report. I hope that it will be possible to organize the same process about the second rule of law report, maybe with a physical presence in the different capitals, because it's quite important to do that. And we also had a constructive and informative second country-specific rule of law dialogue after the German presidency, during the Portuguese presidency, based on the 2020 report in the Geneva Council in April. And another discussion in Justice Council will come next week in June, this month, and will focus on the public prosecution services, the independence of the public prosecution services. I welcome also that the Slovenian presidency has announced the next rule of law dialogue for the Geneva Council, so we continue from one presidency to another one, and it will be a real cycle again. Of course, it's not the only one instrument in our toolbox, and we have a new one, a very new one since the presentation of the first annual report. It's to protect the EU budget, and you know that in December 2020 the EU legislature adopted the budgetary conditionality regulation. and I very much welcome such a kind of new tool. The regulations into force since the 1st of January. So it's very clear. We are monitoring now the situation in all the member states to see how it will be possible to protect the budget against different breaches to the rule of law in the different member states. And you mentioned that I was this morning in Luxembourg to inaugurate the beginning of the operations of the European Public Prosecutor Office. Of course, it's a part of the job to protect the EU budget, to have a real capacity to organize investigations and prosecutions from the EU level. But you know that we have 22 participating member states, not all. And just to mention a few, we don't have Ireland, or Denmark, or Sweden, but we don't have also Hungary and Poland. And it's not by coincidence that you have seen so many discussions on the new tools with Hungary and Poland about the conditionality, because if we are not able to use the PPO to work to protect the EU budget, we need to ask to the national judicial system to protect the EU budget against crime, fraud, corruption, and other kind of situations. And of course, if we don't have an independent justice system in one of the other member states, we need maybe to apply the conditionality. And as for the Recovery and Resilience Facility, the main delivery tool of the recovery, the Commission has now received 15 reform and investment plans from member states. And we will use also the different recovery plans to see if it's possible to make some progress on the rule of law. I want to explain just to say that in the past it was possible to send some country-specific recommendations in the European semester to some member states about the independence of the justice system. And so we try to see if it's possible for the member state to invest better in their justice system, maybe in the human resource, in the digital tools, but also to organize a better independence of the justice system. And so we are working on all those issues. Sometimes it's needed to go to the Court of Justice, and I have explained that about Poland and the disciplinary regime for the judges in Poland. Sometimes the member states are going to the court. It's the case about the conditionality, with a request coming from Hungary and Poland. I want to say in front of the President of the Court that we are quite confident in the solid basis, legal basis of the regulation, but of course we will wait the decision of the Court of Justice. But it's very important to us to continue to work with all the different tools that we have in our toolbox. And I'm very pleased to see that we will have maybe to answer to some questions today, because it's one of the goals, again, that we have in front of us. It's not just to go to the court or to try to discuss with the Parliament and the Council here in Brussels, but it's also to convince the citizens that the rule of law, it's an important element for their daily life. It's not evident. It seems to be abstract for many citizens. And so maybe with such a panel today, but maybe with many other activities in the different member states in contact with civil society organizations, we'll have the capacity to install such a culture. Because we ask to the civil society organizations to send to us some informations about the situation on the ground. It's very important. It's a real source of information for our report. But we need also to help the different civil society organizations to contribute to install such a culture of the rule of law. And of course, I'm sure that we have a lot of things to do to convince different citizens that it's not just an abstract concept for some judges or for some lawyers, but it's very important if you have a conflict with the authorities, with the businesses, or with some other citizens, that you have the capacity to go to an independent, and when it's possible, a qualified and efficient judge to defend your position. And we need to explain that better and better. But I know that we are doing that together with the Law Institute, and I'm sure that with your institute, we'll continue to work on it. So I want to conclude to say, of course, happy 10th anniversary. And I will come back to celebrate maybe the next decades that you will have in your long life as an institute to promote the rule of law. Thank you.
Well, thank you so much, Commissioner Reinders, for explaining those tools to us, and also for your last words. I mean, I couldn't agree more. It needs to be concrete for citizens. Citizens must understand what the rule of law means for their daily life. And so we're already discussing now in the ELI whether the ELI can jointly, maybe with other organizations, engage in the development of teaching materials, also to explain to the young generation what the rule of law, what democracy means for them in their daily lives, and not as some abstract notion they have in their textbooks. So I think that that's extremely important. And I see questions are already coming in the Q&A. However, I would, with your kind permission, suggest we first have a round of statements. So let me turn to you, Mr. Ladera. You're chair of the European Parliament's Legal Affairs Committee, and in particular with the so-called EP right of initiative. Your committee has, and one could say, an emerging role as a creative hub at the Parliament. So now, how do you see this role, and what is the potential in your eyes for closer cooperation with creative institutions such as the ELI?
Thank you very much. It's a privilege and a pleasure to share this panel also with Honorable President Lennart, President Spano, President von Galen, and of course, my dear Commissioner Reinders, to whom I want to take this opportunity to congratulate him on today's announcement on the EU Prosecutor Office. Definitely an historical day for the European Union and to our judicial cross-border cooperation. Madam Chair, members of the European Law Institute, also would like to thank you for inviting me to this event that marks your first decennial. I would have definitely preferred to do it in Vienna and to remember when I was working and living there almost a decade ago, but we'll have to go through this digital era a little bit more until we go back to normal. Also, on behalf of the Committee of Legal Affairs and of the European Parliament, let me congratulate for a decade of work and studies that have contributed widely to the most recent advancement of the European legal culture under the umbrella of your organization. And this first decade of your work, from several points of view, has been tremendous. The quality of its work, the richness of traditions represented by its legal scholars, which perfectly represents the EU motto, United and Diversity, and the multiple of subjects. Jury Committee witnessed with interest the birth of ELI and has since then been willing to seek inspiration from your work. Among the many examples I recall, I would like to mention just two of the most recent. The Jury report on common minimums and standards of civil procedure strictly related to the ELI Model European Rules of Civil Procedure, in cooperation, by the way, with UNIDROIT. Jury report on expedited settlements also of commercial disputes, which aims at reducing the backlog of our courts, a purpose which is shared by ELI study on the relationship between formal and informal justice, the courts, and alternative dispute resolution, and that is even more relevant now that we are trying to recover from the pandemic of COVID-19. On behalf of Jury, I am here not only to congratulate you for your first decade working, but also to offer and to enhance, as you mentioned, Madam Chair, this cooperation in the future areas of common interest. To this end, let me give you just a brief overview of some topics on which my committee is currently working. The first one is, of course, artificial intelligence and digitalization of administrative law and procedures, one of the key issues and dossiers that not only the Commission but the Parliament is trying to push forward during this term, the legal aspects of the data economy. Also, mainstreaming children's rights, which also involves the concept and the role of courts in family and succession matters. Corporate sustainability, environmental liability with new provisions on ecocide. It's a possible future topic also, let me drop the distributed ledger technology and blockchains that may become so important in the future cross-border judicial cooperation. All those as well who follow the work of the European Law Institute will undoubtedly have noticed that all the items I have mentioned correspond to as many ELI dossiers. On those items, my committee will highly appreciate to hear about the state of work, to the state of play on your work. Moreover, I would like to take this opportunity to mention the future issues that the Jury Committee will deal with in the upcoming months. We have the future EU-UK judicial cooperation in civil and commercial matters, something that has not yet been arranged and something that preoccupies widely to many of our companies that work on both sides of the channel. The EU accession to the 2019 Hague Convention on the recognition and enforcement of foreign judgments in civil or commercial matters in the context of the Hague Conference on Private International Law, to which ELI is an observer. the review of the Brussels I and Rome II regulations, and of course the rule of law that has been widely covered by the previous speakers, and indeed is the cornerstone of everything that we want to push forward from the European Parliament. Without rule of law, without judicial independence, and the health of our democracies will definitely not be in shape. Let me say that also the series of webinars on ELI principles for the COVID-19 crisis have been enlightening when it comes to the interplay between the management of a pandemic and the core principles of our democracies. Also, the intellectual property action plans presented in 2020 by the Commission, and on which my committee is now preparing a follow-up report. A follow-up of the Commission 2021 communication on better regulation and the recent Commission legislative proposal for a regulation on a European approach for artificial intelligence. It's probably one of the, let me say, sexy dossiers that we have now at hand, and that all the committees, not only jury, is trying to actually get involved with. In this sense, the upcoming legislative procedure on civil liability regime for artificial intelligence, which may have implication on the most ancient and foundational concepts of civil law throughout Europe, and of which my committee adopted a known initiative report last year. And this is responding to your question, Madam Chair, is when I think that jury has always been a very creative hub within the European Parliament in the context of the so-called EP right of initiative, the Article 225 of the TFU. This evolution is attested by a number of own initiative legislative reports proposed in this and in the previous terms, with prominent success in the areas of artificial intelligence, whistleblowers, on which the European Commission follow up. The Committee on Legal Affairs will, of course, in this role, seek to base its work on a solid academic foundation, to which the ELI not only has widely contributed, but we expect and hope that we will continue contributing in the future. Strong cooperation between the Institute and the European Parliament will allow for bringing together the legislative branch of the Union and academia, democracy and knowledge, politics and legal traditions, future challenge, and ancient foundations, all for the benefit of our fellow citizens. That is why that I'm convinced that in the next decade, we'll continue this fruitful and successful cooperation. And just let me finish by again congratulate you for these first 10 years and for thanking you for inviting me to today's panel. Thank you, Madam Chair.
Well, thank you so much, Mr. Ladera. And in fact, I'm delighted to hear and to see that very long list of topics that are of common interest to the European Parliament and to the ELI. So I took notes while you were speaking, and the list is extremely long. We're really looking forward to be working together with the European Parliament on all these files, and we are always very interested in that cooperation. So thank you very much again. And just a note to the audience, I hear that several members of the audience have a problem posing questions. You have to click on an icon called Stage on the right-hand side. It's not really intuitive, but anyway, it's an icon called Stage, or maybe an equivalent in your native language. And then when you click on that, you can then pose a question in the Q&A. But let me turn to the president of the CCBE, Mrs. von Galen. You represent an enormous number of lawyers throughout Europe, and CCBE is also a founding member of the ELI. So our cooperation has always been a very, very strong one. Where do you see the main challenges which Europe is currently facing, and how can lawyers contribute to addressing them?
Thank you very much, dear Ms. President. And first of all, of course, thank you very much for inviting the CCBE to ELI's 10th anniversary and to take part in this very interesting panel discussion. Just to introduce the Council of Bars and Law Societies of Europe, the CCBE, to the audience, let me just say we are representing the bars and law societies of 45 countries, and through them more than 1 million European lawyers. The regulation of the profession, the defense of the rule of law, human rights and democratic values are the most important missions of the CCBE. By defending citizens' rights, lawyers directly promote the rule of law and are therefore a cornerstone of a society based on fundamental rights and freedoms. And regarding the current challenges in Europe, I would like to highlight some key elements that should be strengthened for the benefit of citizens' rights and their trust in the EU institutions. And the first key element I'm going to mention is, of course, also in my contribution, the rule of law as the guarantee of guarantees. According to the Venice Commission's rule of law checklist, rule of law not only means the prohibition of arbitrariness, but also the prevention of abuse of power. And prevention in this sense requires a high level of control mechanisms for civil society and needs more efforts than just prohibiting the abuse of powers. Prevention requires power in the hands of those who are not on the side of the lawmakers and the state's justice systems, but independent and self-controlled. An independent legal profession is needed to challenge decisions which are taken by those in power. This is exactly why the legal profession is an irreplaceable element of the rule of law. Our role is to make lawmakers aware of bad practice and correct injustices by taking cases to court. Therefore, the independence of lawyers and bars is unconditionally interlinked with the independence of other actors of the judiciary and is an indispensable part of the independence of the judiciary in general. We heard already a lot about the importance of the judiciary, of the independence of the judiciary, and we think, and I think in this regard, there's a strong need to develop a clear rule of law understanding and definition at an EU level that explicitly includes lawyers and recognizes their important role in the administration of justice. Another key element is human rights. We already heard about this as well. And I would like to mention the role of the lawyers. The lawyers are the guarantors of human rights, of citizens' fundamental rights and freedoms. And in this role, unfortunately, the legal profession can come under considerable pressure from the executive and legislative powers, as well as sometimes the judiciary or non-state actors. Harassment, threats, imprisonments, surveillance, hindrances, and murders against members of the legal profession continue to occur in EU member states and candidate accession countries. It is therefore essential to ensure that lawyers are able to exercise their profession in complete independence, freedom, and security. At present, Europe lacks binding legal requirements regarding the independent exercise of the profession of lawyer. There is the recommendation of the Committee of Ministers of the Council of Europe on the freedom of exercise of the profession of lawyer, but this is not binding. We believe that there's a compelling case for establishing a binding legal instrument on the profession of lawyer to create the necessary conditions for effective accountability of states and non-state actors. CCBE therefore calls on the EU member states and candidate accession countries to strongly support the development of a possible future European Convention on the profession of lawyer. This project is subject of a working group of the Council of Europe, which starts its work in 2021. And this project will need support from the European Union. Another important issue regarding human rights is the EU accession to the European Convention on Human Rights. As we know, since the Lisbon Treaty entered into force, the European Union has the right and the possibility to assess the ECHR. And in this regard, the CCBE believes that the promotion of the rule of law, human rights, democratic values, and especially the right of access to justice will find essential and crucial support in the accession of the EU to the ECHR. This issue, which has been pending for 12 years now, has even become more urgent as there is Frontex with enforcement powers. And we also heard already today, the European Public Prosecutor has started his or her work. And the European Public Prosecutor is in principle, of course, bound to national law, but probably not with regard to decisions which are taken in Luxembourg. So it would be a very good move if the accession to the ECHR would happen in the near future. The next key element which I want to mention is the development of a people-centered e-justice. The CCBE welcomes to support the digitalization of judicial procedures, to foster interoperability of different national systems, and to support the uptake of new technologies in the day-to-day functioning of justice systems. However, in order to uphold fair trial rights, such endeavors must always be coupled with sufficient safeguards and due process procedures, including the protection of professional secrecy and legal professional privilege. These safeguards should be ensured in all current and future EU initiatives on e-justice. And to this end, the CCBE calls for the establishment of a structural dialogue and collaboration among all justice stakeholders, such as EU institutions and agencies, national ministries of justice, judges, councils of the judiciary, court staff, and legal practitioners such as lawyers. Such a dialogue could consider the various challenges regarding the digitalization of justice and offer the necessary intellectual and ethical guidance, not only from the perspective of the administration of justice, but also from a user's and practitioner's point of view. When we speak of key elements regarding future challenges, migration has to be mentioned. And in this context, a recent important development is the new Pact on Migration and Asylum. In general, although the CCBE welcomes its aim to create a fairer and smoother harmonized asylum procedure, we are really concerned related to the full respect of fundamental rights and freedoms in the area of international protection and the safeguards for vulnerable persons such as children. We think that such a pact should not be adopted without providing necessary procedural safeguards like access to information, access to effective remedies, and judicial protection. And all this is only possible if migrants are provided with legal aid-based assistance by independent lawyers throughout the whole procedure. Finally, I would like to come to the issue of transparency in the EU legislative process. And there are two topics I want to mention. The first is regarding the trilogue. The CCBE considers that trilogue negotiations should be more transparent. As trilogue negotiations are not officially part of the lawmaking process, they are exempted from the normal transparency provisions. We think that more transparency in this important step of the legislative process would increase the public involvement and participation in the EU legislative process, and therefore increase trust in the legitimacy of the EU. Another issue is the lack of transparency regarding the transposition of EU law in the member states. I think that the dialogue between the Commission and the member states in the EU pilot and pre-litigation phase before a possible infringement procedure regarding the transposition of EU law should be transparent and accessible to EU citizens. Of course, there is the provision of Article 4, number 2 of the regulation regarding public access to European Parliament, Council and Commission documents, which justifies the practice of not disclosing the exchange between the EU Commission and the member states. However, I believe that the concept of this provision, which actually celebrated its 20th birthday 2 days ago, is outdated with regard to the low weighting of the public interest. More transparency in this regard would help to strengthen citizens' rights in the EU member states and enhance trust in the functioning of the EU. To conclude, there are challenges, but there are solutions as well. The EU will need independent lawyers to solve problems and handle the challenges. Rule of law can be time-consuming, complex, and costly. The legal profession is ready to fulfill its role. Thank you for your attention.
Well, thank you so much, President von Galen, for that speech and also for mentioning those important topics. In fact, while you were speaking, I was taking notes, and how serious of potential future ELI projects came to my mind. So I think after that panel, we definitely need to sit down together and have a discussion.
I'm very happy about this because I had the same thought.
Exactly.
Yeah.
So let's do that. I realize we are running a bit late, and yet we have a number of questions in the Q&A. So let me turn to the Q&A. I realize there are two questions from Oliver Mara, which are related. One is arguably directed at Commissioner Reinders, and it reads, could the principle of non-regression also oblige the Commission when taking up its role as guardian of the treaty? And the other one is also related, but I guess it's more directed at President Leonard. Could the principle of non-regression also apply to other values listed in Article 2 of the Treaty of the European Union? So I don't know, Commissioner Reinders, would you like to take that question, the first one?
Well, first of all, it's quite the same kind of question because it's about the principle of non-regression and its use in environment issues. Of course, first of all, on a scientific basis, is it possible to explain that we want to make some progress all the time on such a scientific basis and not to go back to a previous situation with maybe some possible harms to the environment. But if you look to the values and to the rule of law and the different element of the Article 2 of the treaty, of course it's possible to speak about the same kind of principle. We try to make progress, but we don't have exactly the same scientific basis about the definition of the different values. So what's mean the regression? We need first to have some standards, and to be concrete, when we discuss about the independence of the judiciary or about other kind of issues in the rule of law report, we tried first to put in front of the report the standards that we are agreeing on. Article 2, of course, if I'm looking to the values, but the case law coming from the Court of Justice, the case law coming from Strasbourg, from the European Court of Human Rights, and some other instruments, like maybe in the Council of Europe, some decisions of the Committee of Ministers. But again, if you take a decision of the Committee of Ministers in the Council of Europe, it's possible to change their views on some issues. Is it a regression or not? It's not so evident to define that we have tried to do with environment on a scientific basis. But again, we try to make progress, and to answer to the question, of course, we are taking into account the way to analyze the way back in some kind of situations in different member states. But it's not exactly the transposition of the same principle from the environment developments in relation with scientific analysis and the definition of the values. But again, we try to make progress, and we try so to avoid such a kind of regression, but maybe not exactly on the same basis and with the same definition.
Thank you so much. Koen, would you like to comment from the point of view of the court, as the second question was more addressing the case law of the Court of Justice?
Yes, Christian, I would like to add something. In fact, this principle of non-regression has for the first time been formulated by the court sitting in Grand Chamber in this Republica case, which I was already referring to, a judgment of March of this year. And, you know, in these rule of law cases, often the argument is made by a government, yes, but what we do as a member state is exactly the same as in that other member state. And so that is why the Court of Justice indicated that the contextual approach, of which also President Spano spoke, needs to examine whether there has been backsliding. That's really it. President Spano referred to the Secretary General of the Council of Europe speaking about democratic backsliding. So the backsliding can relate to judicial independence, to the rule of law, that is, but also to the principle of democracy, and to the other values of Article 2, maybe not all of them, but quite many of them. The idea being that if there are developments which go in the direction of strengthening those values, even though not everything might be quite perfect already, it goes in the right direction. Whereas when you have a system which was quite in balance, for instance, at the moment of accession of a member state to the European Union, a system on which the report of the Commission was made when giving its opinion on the accession of a member state as to the respect for the values contained in Article 2. And then you see legislative reforms pass, which give the impression of a backsliding, a regression. That places the whole contextual analysis in another daylight. And so we repeated that, like Oliver Mader is asking in the question 4, in this Romanian judge's case, which is recent, of the 18th of May of this year, and the fight against corruption and against fraud. We identified elements which pointed in the direction of a weakening of the state of law, which previously existed. And that is, of course, a very bad development. So we compared, in a way, I recognize this, in the Republica case, the multi-system of appointment of judges with the system in other member states where breaches had been found. And we said, well, here we see a progress in the good direction. In these other cases, we don't see that. And I think question 2 is in fact a suggestion by Oliver Mader that maybe also the Commission might take that into account when, as guardian of the treaties, it is deciding to launch an infringement proceeding or not. And I think that is indeed something which might happen, but that is really for the Commission to decide, because as we say in vested case law, the Commission has an unlimited discretion on whether or not to launch infringement proceedings. So that is not for me to go into that further, but it's just to trace the background of this concept of non-regression and a progression which goes in the right direction.
Well, thank you so much for that explanation. You've already addressed President Spanow indirectly, and there is a question for the ECHR in the chat. It's from Pascal Pichonat. He says, unity in diversity and subsidiarity, this is a difficult triangle. Is it feasible for the European Court of Human Rights to keep up with the subsidiarity principle? Is the bottom-up approach advocated at the heart of such principles of subsidiarity?
Well, I think that is it's a very interesting question. Let me just say, give you a 3-part answer. The first is, it's not a question of whether it's feasible for the European Court of Human Rights or the Convention to keep up with subsidiarity. Subsidiarity is an integral feature of the system. We have always interpreted and applied the Convention in that manner. Point number 2 to the question, is the bottom-up approach advocated at the heart of such a principle of subsidiarity? Absolutely yes, because the idea here is that the Convention comprises a set of minimum standards. Now, within those, the application of those minimum standards at national level, there remains ample discretion, policy discretion. It is encapsulated in all the second paragraphs of Article 8 to 11. What is necessary in a democratic society is initially determined at national level. And the bottom-up approach, as I understand it here, is simply to say, it is first for the domestic authorities to protect and safeguard convention rights. So it is actually the bottom-up approach which is the logic of the system. And that third part, my third point, brings me actually to converging with President Leynertz and Commissioner Reinders on the principle of non-regression as, and I want to compliment again my friend Kuhn for paragraph 63 of Republica, which is a beautiful paragraph. And the reason is that the principle of non-regression of the values, and there, remember, it is referring to the rule of law and judicial independence, as it is encapsulated in Article 19 TEU. So one answer to Mr. Matter would be, well, to the extent that the other values in Article 2 of TEU have a further manifestation in other parts of it, like Article 19, it may actually be the case that the principle of non-regression. But why is it important when we compare the two systems? Because what does the principle of non-regression really mean? It means that there are certain values which are foundational, which will not be called into question if you want to remain in this system. They are what the European Court of Human Rights has called fundamental components of European public order. They include the rule of law, they include the principle of democracy. They are simply principles which do not allow for unilateral regression because they are inherent in the sovereign choice to be a part of the system as such. And judicial independence is an existential issue. It's a foundational issue. Yes, there is flexibility within constitutional parameters to have different models, but there is a particular core to judicial independence, which has been extrapolated and articulated in the case law of the Strasbourg Court, in the case law of the Luxembourg Court. And it is in that sense, like subsidiarity, which grants you reference, but subsidiarity, like the principle of non-regression, is a floor where you will not be allowed to go. And I think both courts have a role in explaining what that is, which we are doing at the moment, and safeguarding it for the future.
Well, thank you so much. I feel that just this one question is one where we could continue discussing.
Maybe not to continue, President. One word, no, just one word to say that before to go to the court with such a question, I said that we are coming every year now with a report on the rule of law. And of course, what is it? It's a presentation of the positive and the negative developments about the rule of law in all the member states. So I mean, when we are speaking about positive development, we are sure that it's a progression in the promotion and protection of the values. When we are speaking about negative developments, we have the feeling that there is a real regression in relation with the values. Of course, such a principle is at the center of the analysis. But again, is it needed on such a basis to go immediately to the Court of Justice about an infringement proceeding? Something else. But of course, when we speak about values and the Article 2, the analysis all the time to see if there are positive developments or negative developments. And it's the reason why we try so to exchange the best practices, if there are some best practices in the way to promote or to protect the values. But of course, it's all the time the same kind of analysis that we have. And I'm very open to continue such a discussion in the presentation of the future, the next rule of law report, also with you and with the civil society organizations, because it's a question of appreciation sometimes. What is the progression, what is the regression? But it's the basis of the annual report, positive and negative developments in the different member states.
Well, thank you so much. As I said, I think this is a topic, a fascinating topic we could continue debating. Let me take one further question from the chat, and I apologize to those whose questions were not picked. It's a question from Robert Bray, and he asks the chair of the URI committee, in fact, how in these days of populism and fake news can we persuade citizens of the importance of the rule of law and fundamental rights in general?
Well, thank you for the question. I don't want to continue with the previous discussion because we could as well touch upon it with these questions. The problem we have now is that rule of law has become one of the main topics that political parties and groups have to get into their political manifestos. Something that when I went at least to law school, rule of law and independence of judiciary, separation of power are things that we take for granted, but now are things that we rally on them. And the problem with rally on them, when I'm from the liberal group, from Renew Group, I'm from a centrist moderate party in Spain, and we have to rally and to put on the top 3 topics that we have to campaign about rule of law and separation of power. And that's the drastic of the situation we're living on. And this is the problem that we have. When you rally on something politically, you polarize someone else. And when you polarize on rule of law and on separation of powers. The problem we have is that you have two sides of society that they want different things, so they have a different approach to the problem. And that's quite dangerous because sometimes politicians, we are not capable of understanding that maybe getting into this polarizing game or trying to rally on something with such importance as rule of law and separation of power, and we use it politically to somehow damage the adversary, is when things are not going right. And I'm the first probably that is guilty on sometimes doing this, because you see things that you don't like on your own government, and you try to use this to try to somehow harm them or control them. And Commissioner Reinders knows perfectly fine what I'm saying about this. So the thing with this is now we need to break that polarization. We have to try to do a more transversal approach to this. We have to understand that whenever citizens that they don't understand exactly what we mean by rule of law, separation of power, and they feel that their countries or their governments are attacked, what we're doing is broaden the difference among us. And that trend, I don't see that the trend is going in the positive way. I think that in that line, probably Commissioner Render position on this is a more pragmatic approach to understand that we can be black or white on this when it comes to approach or to communicate to the public opinion, because if we continue trying to polarize this situation using rule of law as a political tool or a political weapon, I don't foresee a good ending to it. So for me, the goal for this will be to try to de-escalate the use of rule of law and separation of power as political tools to damage the adversary.
Thank you so much indeed. I realize questions are now coming in. It seems like the audience has now managed to find the right icon. Unfortunately, we are running a bit out of time. The second panel is already waiting. So I would like to thank all panelists. It was a wonderful discussion. Thank you so much for your insight. And I think one point, and there were many points where all of you agreed, but one point I think where there was agreement on this panel was also that the rule of law, democracy, is a task for the whole of society, for all stakeholders involved. So it's not something that is for just one institution or a set of institutions. It has to be kept alive. It has to be brought to the people, to the citizens, and the European Law Institute is, of course, prepared to be a stable partner in that quest to enhance the rule of law and democracy and fundamental rights in Europe. So having said that, let me thank all of you very much again. The downside of these online events, or one of the many downsides of these online events, is that you don't hear the applause. We didn't take any steps to kind of, have a virtual applause in the audience room. So we have to imagine the roaring applause that is now in our audience. And thank you so much again. And I hope that we will continue our dialogue with the institutions. And I'm really very much looking forward to that. Thank you very much again.
Thanks to you. Bye-bye.
In the past decade, the European Law Institute has completed 13 projects spanning various areas of the law. This has been made possible by our amazing project teams, but of course also with the support and the combined expertise of our whole membership. ELI projects address key legal issues with an aim to serve the people, companies and organisations in Europe by improving the law or facilitating its application. And I now invite you to join us in looking back on a decade of ELI projects and on the impact they've had.
Report on case overload at the European Court of Human Rights proposed practical steps to improve the way in which the court managed its caseload. Many of these steps have been implemented. ELI's work on sales law provided innovative thinking to move the law forward from traditional sales law to new principles for the digital market. Much of this is now reflected in the EU directives on digital content and consumer sales. Practical guidance was provided by the project on EU copyright rules. The project on collective redress and competition damages claims offered an in-depth analysis for a European framework for these remedies. The growth in cross-border crime required the development by ELI of model legislation for preventing and settling conflicts of jurisdiction in criminal law. This was the first of its kind. The provision of checklists and European standards on detention of asylum seekers and irregular migrants significantly assists judges and facilitates the rule of law. The project on the rescue of businesses in insolvency law provided recommendations for the orderly rescue of businesses in distress. Much of this is now reflected in the restructuring directive.
I certainly think the report has had an impact. The European Commission has looked at it when drafting the directive. National courts have used it, court in Lithuania, for instance, and national legislators, the one in England. And by the way, there's a full Russian translation of the report.
The ELI ENCJ project on courts and alternative dispute resolution provides practical guidance to judges and practitioners in navigating alternative methods for resolving disputes. The toolkits produced by the project on empowering European families support international families in Europe by providing assistance to lawyers and promoting family mediation. The ELI model rules on online platforms provide a balanced approach to transparency, fairness, and liability in the newly emerging and rapidly growing platform economy. The project on the protection of adults in international situations sets out a set of measures that the EU could take in order to enhance the protection of adults in such circumstances.
In the space of a few years, the international protection of adults, once a largely neglected topic, has become a priority for the EU institutions, as attested by the programme of the Portuguese presidency and by the study that the Commission has recently launched on this matter. The ELI Adults project was crucial to this development. Its report is a constant reference in the debate. Further developments are expected to arise in the coming months, and the ELI continues to have a very important role to play.
The ELI Unidroit model rules of civil procedure provide clear proposals for the further harmonization of procedural standards and the reform of domestic litigation by promoting fairness, speed, and effectiveness in judicial proceedings.
7 years ago, the European Law Institute and UNIDROIT began an ambitious joint project to develop modern, efficient and fair rules of European civil procedure, adapting the existing ELI UNIDROIT principles to a regional dimension. The resulting ELI UNIDROIT model rules have already influenced the debate on law reform before their final publication. We are confident that they will continue to inspire academics, policymakers, and practitioners in Europe and beyond.
In our fast-paced digital age, there is an increased need to regulate areas that have a direct impact on our lives and on the lives of future generations. ELI is therefore engaged in developing innovative ways of addressing the most pressing legal issues of our time. ELI has grouped its ongoing work into three main thematic pillars: the rule of law.
There is no effective judicial protection nor mutual trust without independent courts. To address the challenges faced by any of the EU judiciaries, we are turning the international Mount Scopus standards of judicial independence into some European standards, specifically tailored to the situations of the EU judiciaries. These standards will bolster the values of the rule of law, and they will provide major guidance to overcome the challenges ahead.
Law and governance for the digital age, sustainable development. With 11 ongoing projects currently under these three thematic pillars, ELI is driving the agenda forward to ensure the law provides real benefits for the protection of citizens, professionals, and the institutions of the state and of society. ELI is conducting these projects on its own and jointly with other organizations, both in a European and in international frameworks. The project on principles for a data economy, for example, is being undertaken jointly with the American Law Institute. This will shape the future of data rights and transactions on both sides of the Atlantic. After hearing and seeing that slideshow, we now turn to the second panel discussion. This will look forward, but take advantage of the experiences that have been gained from the projects that have been outlined in the slideshow. For that purpose, we have Rector Heinz Engel, rector of the University of Vienna, who has been the pillar of strength of ELI over the years it has been in existence. We then have Judge Bénédicte Fauvat-Causon, a judge of the French Conseil d'État. Then we have Professor Imar Gries, who was instrumental in the founding of ELI when president of the Supreme Court of Austria. And those two will show what it is like looking at it from the inside. But no organization can afford merely to look at things from the inside. We need to look at it also from the outside. And therefore, we are greatly privileged to have with us Anna Joubin-Brett, who is the Secretary General of UNCITRAL, or the United Nations Commission on International Trade Law, which has played such an important role and with whom we have worked in close cooperation. And then we also have Dr. Adam Tud, a Hungarian notary and president of the Notariats of the European Union. We look forward very much to their debate on this issue.
Thank you very much, Lord Thomas. It is my turn also to thank you all for being present to celebrate the ELI's decennial, especially by attending this second roundtable. We will have a Q&A session at the end of all 5 presentations. So dear participants, do not wait until the end to post your questions. You did it in the first round already, so you can just do the same and go on the Q&A function. Now that we are all set, it is time to begin. and give the floor to Professor Heinz Engel, Rector of the University of Vienna. Rector Engel is also a renowned professor of industrial mathematics at the University of Linz, who got several prizes. He's also honorary professor of Fudan University in Shanghai and full member of the Austrian Academy of Sciences and of Academia Europaea. But today, Rector Engel will address as the rector in charge of the university in which ELI Secretariat has its seat, as well as the home university of our actual president, Christiane Wendehoff. It's important to stress here that the University of Vienna has been substantially contributing to the ELI during the last decade, both financially and in other ways, of course. So it is with a spirit of deep recognition that I have now the pleasure to give the floor to Rector Engel for his words.
Thank you very much. As has been said, I'm a mathematician, but still as a vice rector for research at the University of Vienna, I had decided in 2011 to submit a bid, also a financial offer, for the establishment of the ELI Secretariat at the University of Vienna. And fortunately, we are successful in that. And since then, the Secretariat has been in Vienna. In 2018, ELI and University of Vienna extended the cooperation for 4 more years until the end of 2023. The purpose of cooperation between ELI and the University of Vienna is, of course, the enhancement of research, recommendation, and practical guidance in the field of European legal development. And let me say that I'm very impressed by the report we just saw in the video about projects which have been conducted, and especially about future and currently running projects. They also, of course, influence my own field of science in the sense that blockchain, which is actually a mathematical technology in the end, and also artificial intelligence play an important role in your recommendation. The University of Vienna has agreed to continue its support for ELI to the same extent as before until the end of 2023. Now, in 2023, there will be a change in rectorate of the University of Vienna. So I will not be in charge in extending this agreement, but if asked, I will certainly recommend to my successor, whoever it will be, to continue with this quite successful arrangement. And we are, of course, very proud of the fact that the ELI General Secretariat, and therefore also somehow its center of gravity, is and remains in Vienna. Why is the ELI important to us as a university with a very large and internationally oriented law faculty? We as a university, in particular the Faculty of Law, are striving to be intensively involved in the existing cooperation and to make use of the associated opportunities for Europe-wide networking. Both the University of Vienna and ELI are reaping the benefits of these cooperations. Our scholars are able to influence and contribute to the development of law at the European level. And I'm, of course, very pleased that Professor Christiane Wendehoff, Professor of Civil Law at the University of Vienna, is currently president of ELI. One of the University of Vienna's stated goals is to involve its scholars, its legal scholars, but also students, especially graduate students and young scientists, even more extensively in the ELI's project and activities. I might want to mention that we currently initiate, or we start actually in fall, with a second curriculum in law, namely a bachelor's and master's program in internationale Rechtswissenschaften. And we also just established a quite prominent and well-funded doctoral schools in legal studies. Our scholars are happy to use the expertise to support ELI in realizing existing and new projects. Our existing collaborations offer an outstanding opportunity to further expand and to intensify the cooperation between ELI and the Faculty of Law, and even broader to the University of Vienna in the future. And I'm quite sure that my recommendation to continue this cooperation will certainly be heard by my successor, whoever that is. So I wish the ELI as much success in the next 10 years as it obviously had until now. Thank you.
Rector, thank you very much indeed for such a warm address and for all the support you've given ELI. It's pleasing to know that even in the very rarefied areas of mathematics, law plays its role. So thank you very, very much for what you've been able to say to us tonight. We turn now to Bénédicte Favard-Cozzon, who's currently a judge of the French Conseil d'État. She was the life and soul of the start of ELI, a very, very progressive academic, and who played a part in making certain that we got off to a start. Because like in every aspect of life, we all know that the early years, particularly the very first years, are so important. So we look forward, Bénédicte, to what you have to say about our experience is from the past and how we can go forward to the future.
Thank you very much, and thank you for these kind words. It's a great honor to participate in this event. And before all, I would like to congratulate our President, Christian van der Horst, and the Secretariat, and all those who actively participated in making the ELI such an active forum with multiple faces and stakeholders. Because from its very beginning, the ELI has successfully met many challenges. The most extraordinary one, in my opinion, was to bring together academics, practitioners, institutional actors in a common project for European Union ruled by law and also by the best possible legal instruments. And the ELI output has principally been achieved so far via projects. We've mentioned them earlier, and these take the form of statements or instruments, and the diversity of projects testifies for the wide range of competence of ELI members in all fields of the law. The publications of these projects is a highly scientific activity. In this respect, I may say that the ELI is a bit elitist, and little by little, the ELI has embarked on other activities. It has established national hubs, SIGs, it has started new cooperations, it has recently launched a new innovation paper series to enable members to propose pioneering ideas. Some years ago, the Council engaged into a discussion as regards the possibility of developing a new activity linked to education. At that time was not ripe for this young association to engage into this adventure. However, now that ELI has successfully showed its ability to take up all sorts of challenges, I would like today to launch a call for action in the field of education. I will first point out 3 good reasons for doing this, and then briefly present 3 concrete ideas in this respect. The reasons are the following. As was said earlier by Kuhn Lennart, the ELI is the voice of European legal civil society. In order to fulfill this task and to help bridge the gaps between different legal culture, as well as between scholarship and practice, I believe that the ELI could now embark into a European digital education project. The second reason is that I cannot think of any other independent organization which could so aptly take up this challenge. The richness of the Institute is the diversity of its members. They consist of experts of institutions like Supreme Courts, of universities, of law firms, professional bodies, and this variety is invaluable for European education projects. The third reason is that no democracy can thrive without an active and educated civil society. Education forms part of an enabling and supporting environment for a European civil society. I now turn to the 3 concrete ideas that I would like to put forward today. First, what about schools? The study of the rights and obligations of citizens in society already form part of the curriculum in schools. And there is a course which is usually called civics. It's not always taken very seriously by the professors, and by the school boys and girls. I think it would be interesting, as part of ELI's work, to observe and compare school programs related to civics, to make suggestions adapted to each country, to enhance the status of the course, and possibly to do this by creating a new option, particularly for last year in school, which will be an option dedicated to the law and contemporary challenges. And in fact, this idea is based on a new experience that we have just had in France in the context of the reform of the French baccalaureate, because this option has just been introduced and it has met a tremendous success. In French, it is called Droit et grands enjeux du monde contemporain. The second idea concerns universities. An idea will be to introduce a new course which could first be dedicated to Erasmus students in all disciplines, not only those who study law, but also those who study economics, chemistry, medicine, literature. And a suggested title for this course, inspired by ELI, could be Wealthy, World, Europe, Law, Challenges and Innovation. And the idea would be to present, of course, legal institutions, but in a very active and dynamic perspective, with hot issues such as climate change, development of technologies, fundamental rights, etc. This course should be very practical. It could be based on case teaching, on cases from the European Court of Justice. It would interlock European and national legal orders, particularly the legal order of the university, and thus provide Erasmus students with a better cultural insight of the country where they're spending 1 year or 1 semester. Such an initiative, in my opinion, could be launched by the ELI and supported by European institutions in the context of Erasmus Plus programs. And it could be also initiated by European universities, which are transnational alliances promoting European values and identities. Of course, European associations of students should also be associated to this project. But I believe that in the long run, this experience and this course should be expanded to all students, not only Erasmus students, and there is still a long way to go. The last and third concrete project concerns lifelong learning, which has become so important today. And I will keep it short and just make here 2 suggestions. We could create an ELI resource center with educational materials on a broad spectrum of topics which have a link with ELI projects. It will be also a means of making our projects known by a wider audience than they currently are. And we could also create an online ELI teaching center and link it to other institutions which have professional programs or summer schools, like in Salzburg or in Paris, and create new alliances with all these professional programs that are being developed. Because very often, when I have been speaking about this new course in France, Droit et grands enjeux du monde contemporain, I've met people who always said, well, this is something I would really need to take, a course that is very useful beyond schools. To conclude, I believe that since 10 years, the digital revolution has opened new opportunities. It also created new challenges, in particular, as regards misinformation. And democracy relies on educated citizens, as I said before, and this need is great to uphold and to promote the common value of the rule of law, which is so dear to us. ELI's mission is to enhance a better European integration. To this effect, its tasks are various. And the ELI, again, I will say it because I really firmly believe it, is a unique forum It's a forum where lawyers from all over Europe, but also from all over the world. We heard from Rainer Zimmermann this afternoon that we have members from 62 nationalities. All these lawyers exchange ideas and they learn about each other. It's the voice of a European legal civil society, as Kunlinot said. It's a holistic enterprise. And in fact, a majority of members are academics. So it's a bit surprising that we have not been involved in education before. I really think that time has come, based on the ELI acquis and based on new technologies, to develop teaching tools and digital education initiatives with a view to upholding and spreading the common value of the rule of law in Europe and beyond.
Thank you very much. Thank you very much, Bénédicte Fauvard-Cosson, for these stimulating three very concrete ideas, which I'm sure will be discussed further by the ELI. But thank you also for your dynamism at the start of the ELI and manifestly, which you show in a renewed way today. I have now the honor and pleasure to give the floor to a Supreme Court Judge, Irmgard Gries, former president of the Austrian Supreme Court. She's also an honorary professor at the University of Graz, served as the president of the network of the presidents of the Supreme Judicial Court of the European Union. But more importantly, today she's a founding member of the ELI, one of these happy few 56, I think, and actual deputy speaker of the Senate. In that position, she had a unique opportunity to follow the evolution of the ELI during these last 10 years. I'm thrilled, therefore, to listen to her contribution. Judge Gries, you have the floor.
Thank you very much. A 10th year anniversary is an opportunity to take stock of what has been achieved. How can the ELI be characterized today? For me, the ELI is a truly European institution. Bénédicte Fauvard-Cosson has described it in a wonderful way. And it has been it from the very beginning. It started with jurists of different European countries, academics and practitioners having the same vision. The vision of an institution, a counterpart to the American Law Institute, a European Law Institute. The first steps were taken in meetings in Florence, at the University of Europe, in Vienna, at the Supreme Court building, and then in Athens. One could say that the birth certificate was issued in Brussels because the European Law Institute is a Belgian association. And, so to say, the baptism party took place in Paris. It was a great event, and wishes and expectations for the newly founded institute were expressed. It was expected that the institute should possess convening power, catalyzing power, and thus identifying power. What is meant by these properties? Convening power means more than just the ability to organize conferences. What the European Law Institute was expected to do, and what it really has done, was to provide a forum for discussions and cooperations, not only among academics and among practitioners, but also between these two groups. And if theory and practice join the efforts to solve legal problems, this guarantees workable solutions. This is meant by catalyzing power and is shown by the results of ELI projects. These videos were very, very impressive, and it's great what has been achieved in these 10 years. And thus, the ELI proved its identifying power by giving EU law and also the European jurist a face. one could say that its efforts have resulted in building up different pools of capital: financial capital, human capital, and reputational capital. Financial capital is perhaps the weakest point, but thanks to the University of Vienna, and Rector Engel was from the very beginning on board and prepared to assist and to finance the General Secretariat. And thanks to the university, a basic financing has been provided from the very beginning and still is. And the many fellows from all over Europe, not only from Europe, there are fellows from more than 60 countries, form the human capital of the Institute. And at the same time, the membership fees are also a funding source. The excellent work of the last 10 years manifests itself in reputational capital. The ELI has a name in Europe, and it has become an esteemed institution, a valuable sparring partner in legislative matters for the European Commission and the European Parliament. All this wouldn't have been possible without the commitment of numerous jurists from all over Europe and even from more countries. Their commitment has made it possible that the vision of a few became true. And for the future, I would say, for me, the most important topics are to do all that is possible to guarantee that the rule of law, the human rights, the independence of courts are respected in Europe. We live in a time where this doesn't go without saying anymore. And it has become so important for all of us, for everyday life. And therefore, it needs an esteemed institution like the ELI to really raise its voice and to stand for these values, which are the pillars of our civilized society. Thank you.
Well, that was magisterial in its overview, in a way only someone of Ingmar Griess's extraordinary career can give. It was so wonderful to hear the various ways in which the Institute was looked at in three perspectives. And it was a great pleasure and privilege to hear from you. I shall return to that at the end. But can we now move to our next speaker, who's Anna Joubin-Brett. Having heard her speak in Vienna at one of our conferences, and also knowing the huge and profound influence that UNCITRAL has had over its longer existence than ELI, but a profound influence it has had, it is important to hear from the international perspective, because no nation, no association of nations is an island unto itself. It has to live in a fast-changing world. And so from an external perspective now, we look forward to hearing from you.
Thank you very much. It gives me a great pleasure to address the ELI membership on this auspicious day of celebration, the 10th anniversary of the ELI. It's for all of you an opportunity to look back with pride at the tremendous work that has been accomplished and that we've just seen displayed in this video projection during these 10 years, at the research projects, the conferences, the publications, and the meetings you have organized. But it's also a good time to look at the partnerships that you have established over the years and the synergies that have emerged from these partnerships. And this is what I would like to bear witness to today. Over the years, UNCITRAL has taken part in various projects as a project observer and has been part of your membership as an institutional member. And this could be an end in itself, and we could congratulate ourselves on this nice partnership on paper. But the reality is that it has been much more than that, and that the ELI's role as researchers and proponents of new areas of the law, of areas that need to be developed and of areas that need to be harmonized, has played in full, at least in the area that is relevant for us, namely international trade law. A concrete example is the pioneering role the ELI has played in the development by UNCITRAL of its exploratory and now preparatory work in the area of the digital economy. Let me be very honest with you. It is ELI's work on the principles for a data economy that first brought our attention to the legal aspects of the digital economy and started the Secretariat's interest and exploration of the matter. Thank you, Professor Wenderhorst. You put it onto our radar screen, and this is how it should be done. Early on, when researching the economic environment of the digital economy, it became clear to us that the two main drivers of the value creation in the digital economy are, on the one hand, the data economy or digital data, and platformization, also called the platform economy. To look into the data economy, the valuable project developed jointly by the ALI and the ELI gave us some very useful guidance about the legal issues, where were the gaps, and what were the needs. We have developed a proposal for future work that will be presented to the Commission at this forthcoming session. It may not be the first one in the work on digital trade, but we want to continue exploring, understanding the needs better, and from there make a stronger case for future work in this area of the law, where there is still a lot of uncertainty, a lack of clarity, and sometimes even a lack of understanding of the issues at hand. Similarly, the ELI report on the online platforms has been a valuable basis for our proposal for future work on online platforms in trade, but also in dispute resolution. What a forum of academics can propose and recommend is usually, and rightly so, more ambitious than what we in an international organization can actually put on the table. But this catalyzer effect cannot be understated. We approach the legal landscape, and I should say in the necessary terms when speaking about digital economy, the ecosystem of the digital economy, through a taxonomy of digital technologies that served both as a methodology for us and as a product in support of our legislative proposals. In this taxonomy, we sought to identify the components of the data economy and of the platform economy, and we looked at the flurry of new technologies, the AI-driven transactions, the AI-driven dispute settlement, applications of the blockchain that Professor Egel just presented to various areas of UNCITRAL framework, be it secure transactions, MSME registry, tokenization of assets, their treatment in asset recovery or in insolvency and secure transactions or other areas of trade law, and of course, the online trade and dispute settlement through online platforms. But we did not want to be carried away by the technologies, but rather we wanted to look at them through the lens of how these technologies impact, simplify, but mostly also disrupt commercial transactions we are used to, and where the existing legal framework is not adapted, or where existing texts cannot provide an answer or a rule. This would be the first aspect of future-proofing for instruments and tools to be developed as part of the new work on digital trade. We need to make sure that the fundamental UNCITRAL principle of technological neutrality is foundational to any of the work we carry out in this matter. A little bit of self-congratulation on this occasion. When you look at the texts on electronic signature or electronic commerce that were developed in UNCITRAL, they were developed in the early 1990s. So 30 years later, they have come, I would say, to their full achievement in the electronic transactions that we're experiencing every day, and all of us. Another aspect of future-proofing is to look at the existing UNCITRAL text, particularly the frameworks in the areas of electronic transactions, and to start looking at what made digital transactions different from the existing and the ones we know more as electronic transactions. Here again, the exploratory work carried out by ELI in various of its projects has been a solid resource for us in identifying the issues and making the case for modernized law in international trade. But what has become more obvious for us as we witness the rapid spread of digital technologies, boosted to a large extent in the area of international trade by the COVID-19 pandemic, that has shown all of us how much the international supply chain depend on machines when the human beings cannot be at their workspace, and that how much this spread of digital technologies is a potential for an abysmal digital divide that is already leaving many countries behind. That wealth creation in the digital economy is concentrated in two countries, China and the United States, should be a wake-up call for the legal community, and also sensitize us to the fact that harmonization, facilitation, free access, interconnectivity, interoperability, and recognition are the key words to help states achieve the targets of the Sustainable Development Goals and ensure that at the end of the day, the digital revolution works indeed for all. I hope that we can continue to draw on the energy and the creativeness of the ELI to deliver on this important task for the international legal community. I thank you very much.
Thank you very much, Ms. Anna Joubin-Brett, for your very warm words. Also, thank you for recognizing what you call the catalyzing effects of ELI's work, especially in the field of the new technologies. At the same time, you gave us a whole list of future potential field of work by UNCITRAL and, or I wanted to say, with the collaboration of the ELI. So we look therefore forward to continuing our fruitful collaboration in the future on these or other projects. I have now the pleasure to give the floor to President Adam Todt. He is a public notary from Hungary who has been the president of the Council of the Notariats of the European Union since January 2021. He has been a member of the presiding board of a disciplinary court of the Territorial Chamber in Budapest since 2004 and the vice president and now president of the Hungarian Chamber of Notaries. He is also an associate professor at the Faculty of Law of the Eötvös-Loránd University in Budapest. The Council of the Notariats of the European Union has been an active partner of the ELI for several of its projects. It is therefore interesting to see how this collaboration has been perceived, and therefore it is my pleasure to give you the floor, dear President Todt.
Thank you very much for the possibility to summarize or use and the chance to speak to you. Well, the CNUE has been present since the creation of the ELI and participated in the inaugural conference of the European Law Institute in 2011 in Paris. Since then, the organization has been involved in the various institutional bodies of the ELI. So well, I am ex officio a member of the ELI Council, but this is not, so this is a list important. Several countries are members of the ELI countries, like Julius Forschner, Corrado Malberti, and Francois Tremosa. And various notaries are involved in the ELI special interest groups, business and financial law, family and succession law, and digital law. The CNUE shares the objectives of the ELI. The initial objective of the ELI was to respond to a request from the scientific community and the European institutions to regroup within multidisciplinary structure. From now on, the ELI's ambition is to be a real laboratory for legal harmonization in Europe. The Institute does not limit itself to the study of the law of the member states. It studies the possibilities of approximation between the different systems and wants to be a force for proposals to the European institutions, as we can see. Finally, the ELI aims to make European law better known for the benefit of citizens and national lawyers alike. The CNUE is fully in line with this logic in its work. The CNUE is a source of proposal for the European institutions. We have some examples, the creation of European legal instruments on succession, matrimonial property regimes, and registered partnerships. This has also been the case for the creation of online companies, and we also intend to be involved in the forthcoming work on digitalization of judicial cooperation in Europe. The CNUE is supporting the networking of European notaries via the European Notarial Network, and more than 2,000 notaries have access via this secure platform to set up of practical tools to facilitate the handling of the cross-border cases. We have also created a series of information websites for the general public, Succession in Europe, Couples in Europe, the Vulnerable in Europe. And we are also involved in the training of European notaries, which is one of the European Commission's priorities. Since 2014, more than 5,000 notaries have participated in our trainings. Over the years, an effective working method has been established and the results are there. It is important for the CNUE that the constant search for dialogue and respect for the different legal traditions are at the heart of the ELI's work. Some examples from the recent work, the empowering of European families towards more party autonomy in European family and succession law. This project aims at reducing obstacles faced by international families and facilitating free movement of citizens by providing better certainty and predictability of results, and reducing the costs of litigations in matters of family and succession law. It also aims at promoting the use of family mediation in the EU. Another project, the protection of adults in international situations. The outcome is an analysis on the protection of adults in international situations. Where appropriate, it includes proposals regarding such protection, as well as further issues surrounding the application of the Hague Convention of 2000 on international protection of adults. We have some ideas for the future work. the consequences of Brexit in the field of civil justice. The ELI should reflect on common solutions to assist citizens living in the United Kingdom or in the continent in dealing with the many legal issues that will arise in their daily lives. In February this year, we have launched a project, the MAPE Successions, which is co-funded by the European Union. Over a period of 2 years, this project aims to analyze the implementation of the European regulation on international successions in 22 European countries. The results and conclusions in the form of study will be presented to the European institutions in 2022. The outcomes could also be of interest for ELI. In its European Judicial Training Strategy for 2021-24, released last December, the European Commission ambitious objectives and broadens the scope of training to include new subjects, such as digitalization of artificial intelligence and innovative teams and methods. Training could be maybe another area for the ELI to share good practice among practitioners. So thank you very much.
Thank you very much indeed, Doctor, for that very comprehensive talk. It's always excellent to hear from notaries who bring real practical experience and have enriched many of our projects. And thank you for your suggestions for the future. We now turn to the questions session. You will see in the chat that 1 or 2 questions have been asked, but there's still time to ask a question inspired by the wonderful speeches we've heard so far this evening. So may I encourage you to do that. But let me ask the first question. It's a short one, which says, what experience of ELI are you most fond of? I can't resist asking Professor Judge Ingvar Gries for her views, having been present at the creation.
For me, the greatest success is the joining of academics and practitioners and work together to come to workable solutions. It's so important for the citizens, it's important for the lawyers, it's important for the judges that we have a law which is fair and understandable. And if practitioners and academics work together, there's a good chance that we achieve this success, that we have this success. So for me, that's the greatest advantage of ELI, to bring people together.
This is excellent, of course, and since people are together, we will continue with a number of questions. And I see here that there is a question to Ms. Joubin-Brett. And the question is, if you could offer ELI one piece of advice, what would it be? You spoke about, of course, the catalyzing effect and so on, and how we had already positive aspects, but probably you have more advice to give us. So please.
Thank you very much. I think I would definitely not give any advice because I'm not very well positioned to give a piece of advice. But I think that from the experience we've had working together with the ELI and the impact of the role of the ELI in our legislative development, I would suggest not to shy away from taking, for the ELI, to take an additional step as an advocate or a proponent for any future work in the area of legislative developments or harmonization, and to bring them to UNCITRAL. I know that it's not in the DNA of European academics. It's very much in the DNA of American academics to, be to promote strongly the development of legislation in which serves for their field of the law. But I think that maybe a greater proponent role by ELI in our forum would be most welcome and would maybe retilt the balance a little bit. So that would be a suggestion which is completely self-interested. Thank you.
Thank you very much. But it is also well noted. John, do you want to ask the next question?
Can I ask the next question, which comes from George Berman and is addressed to Benedict? Do you see prospects for ELI not only to launch educational programs on its own, but also to integrate its work with institutions whose constituencies and audiences already exist?
Yes, and thank you very much, George, for asking these questions. I'm sure you anticipate my answer. Of course I do. And I even think that it is in the DNA of the ELI to cooperate with other institutions, like Mrs. Joubin-Brett has just explained us. So not only do I see prospects, but I strongly believe that we must work with institutions and who have audiences already and who have ideas on this subject. We shouldn't remain on our own. We have always been eager to work collectively and to promote cooperation with institutions.
Indeed,
so if you have ideas and suggestions, they are welcome. And there's already one institution calling.
Thank you. Thank you very much, Bénédicte Fauvard-Cosson. And indeed, we've heard from President Todt that the European notaries were also looking for being trained, or they are training themselves, also using the material that came out of some of the ELI projects. So I was wondering, President Todt, you mentioned future projects, but maybe listening to Ms. Joubin-Brett stressing also the digital age, I was wondering how one can bridge the gap between digital age and, training the European notaries.
The pandemic enforced that form. So the use of the video conference as we are meeting now, and these became a general tool for education as well. But I think several topics should emphasize, and for us is the changing of the tools. And that's why we are speaking about the digital projects, because we are almost sure that in some years all over Europe, the paper will disappear from the notarial offices. And also, it was quite dangerous to meet the notary because of the risk of the infection. So in some countries, they started to create, like in France, the notarial deeds with the help of a video conference. The more courageous led them to sign it in distance with electronic signature. In those countries where the electronic use of electronic signature is not so widespread, the clients should have entered to the office at least to sign the deed. But I think for us, this is now the greatest challenge, how to make more simple, how to make faster or procedures, but to preserve the security and the traditional role of the notary.
Thank you.
Can I ask one last question of the rector? You were very modestly said when we started that we were all legal scientists. I don't think many of us think we're scientists at all, just mere lawyers. But as a distinguished mathematician and coming from a real scientific background, how do you see the way in which the point that President Gries has brought forward, which is bringing practitioners, bringing academics together? What lessons do you have from other aspects of life where you bring people together? And what can we learn from that?
First of all, I think I said legal scholars, not legal scientists, because I realized the scientist in the English language is mainly natural scientists. So I consider you as legal scholars. But as you said, or somebody said in my introduction, I've been professor of industrial mathematics. And that's the same as you are dealing with, namely bringing a very theoretical or theory-oriented field, namely mathematics, together in joint projects with industry. I've done a lot of that, also on the European level, so I know how difficult this is, and that's also the reason. The first question was, what do you admire most about ELI? I would say that my expectations about the success of ELI in bringing these practice and theory together was actually much less than what happened so far, because I know how difficult it is, and I think I admire a lot the success and these varied cooperations which you had so far. But let me add to one other question, namely, when developing teaching programs, do you have to cooperate with others? Of course you should. And especially I recommend universities, of course, because at my university, we have from one day to the other switched our education to digital education. And we are a huge university. We have 90,000 students. Only a small percentage of them at the Faculty of Law. We have 20 different faculties. So this was a big, major event, also with a lot of technical or technological innovation. But what we are now thinking of is how will the university be after the pandemic, if it ever ends? It will certainly not be the same as before, but it will still be a, what we call in German, Präsenzuniversität, a university which is mainly based on meeting between different people, but in a very different way as we have done so far. And I think that leaves a lot of cooperation also within your field, and our law faculty also is one, at least some of people at law faculties, at our law faculty are on the front of this development. And I think, well, we have to partner with universities, and or you have to partner with universities in this enterprise, and also with European networks. Of course, we are also involved in European networks of various kinds, but I think these ideas are very good, but also one has to focus because they are very difficult to realize.
Well, thank you very, very much indeed, Rector, for that really outside advice. We are very, very grateful. But can I say what a privilege it has been for me to chair this discussion, bringing together those that founded it, those that have guided us along the way, and those that have been such enthusiastic supporters. It's a real privilege to have been here tonight. And I just wanted to say thank you, and to thank you, and thank you.
So I would just add, but when a judge has spoken, nothing more is to be said. But however, I would also add my many thanks to all 5 speakers and to all of you for your excellent questions and this participation. I do hope that this decennial is not just a way to look back to what has been achieved, but truly a motivation. And that's what I sensed during this second panel as well, a truly motivation and a source of inspiration to go forward with even more energy in the next years to come. We all know that celebrating is really all about gathering together in a unique moment to getting positive feelings and energy to go forward with a creative spirit. I therefore want also to say how enjoyable it was for me to co-chair this panel with Lord Thomas. I truly look forward to continuing to collaborate with him in the years to come. But it is now time for all of us to listen to a live performance prepared by Elisa Schmidt, violinist, and Maria Radusin, pianist. Both are truly European musicians coming from different countries, Hungary and Serbia, who both came to Vienna to pursue their musical careers. They both have performed on many stages across Europe, such as in France, Germany, Spain, and will perform for us tonight 3 pieces full of joy celebrating this decennial. As a unique event for this decennial of the ELI, they will play live for the ELI audience. 3 pieces, in fact. First, but they will present that. But first, Georg Friedrich Händel, a German composer, has composed a piece called À la Hornpipe for its water music, which refers to Scotland. So all European again. And Fritz Kreisler, an Austrian-born American violinist and composer. And I suppose that the musicians chose this piece to show the excellent relationship the ELI has with the American Law Institute. Well, these are old Viennese melodies, Love, Sorrow, and Lovely Rosemary. Probably that will also fit to our relation. I hope so, at least, that we will continue this excellent relationship. I'm sure you will truly enjoy this live performance by Elisa Schmidt and Maria Radusin. Thank you very much. And now, please, to music.
Dear friends of the European Law Institute, and maybe I should say dear ELI family, after those lovely pieces of music, it's time to say a few words of thanks. Thanks to all speakers of today who supported this event with their messages, with their very important guidance, which will be extremely helpful to the ELI for the coming years. Thanks to the musicians who made this event so lovely, because it would have been really boring if there had just been lawyers on stage speaking about law without music and without these lovely sounds, in particular from my beloved city, Vienna. This wouldn't have been such an event as it has been. Thank you so much to our audience who spent their time with us, who posed their questions in the chat. We apologize again that we were not able to take all the questions, but let me assure you that we will stay in close contact with all our membership. And if you have questions to ask to the speakers of today, don't hesitate to send them to us via email and we will forward them. I would like to thank all the institutions that are supporting us and that have made this event possible. The University of Vienna, the European Commission, and I would in particular like to mention the role of the Commission representation in Austria that was extremely helpful in facilitating this event and without which this would not have been possible. And of course, the European Union Youth Orchestra with their lovely Ode to Joy, which I have to confess was a secret wish of mine. And, you know, when you look back upon your presidency, among the things I haven't achieved is, you know, to play the Ode of Joy at every ELI annual conference. So maybe I can say that as a kind of a wish to my successors. Maybe it will be possible to realize that in the future. All this wouldn't have been possible without the great support of all my colleagues in the ELI bodies. First of all, my wonderful colleagues in the ELI Executive Committee, without whom it wouldn't have been possible to launch such an event or to lead the ELI and to achieve what has been achieved. So thank you so much to all my colleagues in the Executive Committee, in the Senate, in the Council, and of course to the whole ELI membership. But there is still one group of individuals whom I would like to mention in particular. It's such a pity we cannot call them all onto the stage now, but this is our wonderful, amazing Secretariat staff. They've done a wonderful job putting this together and making this become real. And I would just like to mention in alphabetical order, in particular, Jessica, Katja, Tomasz, and Susanna. And of course, in the background, Petra and Sebastian, and then all the support we received from Brutkasten Media and Dominika. So thank you so much. You cannot imagine at what times of the day or the night our staff has been working, and we received emails from them, and they were tirelessly working towards making this become a reality. It was particularly difficult for them because, as many members of the ELI will know, the initial idea had been a physical event around the time of the annual conference in September. But when we realized that there would still probably be restrictions, that some of our members might not be able to travel, that it would maybe not be a good idea to plan for this event as a physical event in September. And we changed the date to the 1st of June. This really put our wonderful staff under pressure. But they took the challenge and they really succeeded in making this a great afternoon. So thank you so much to all of you. And I think it's impossible to create that applause, but maybe I can just clap my hands like this, and I see all those that are still in the backstage room clapping their hands too. So please take it as a kind of symbolic applause for everything you have achieved. So this decennial celebration is now coming to an end. It made me realize again, I have to say, how timely it was for the ELI to be established 10 years ago, how important it is that we have an institution that has as its goal to represent the European legal community, because that was really something that was missing in the landscape of European institutions still 10 years ago. And as a legal scholar of my age, you know, it's always a difficult decision how to invest 10 years of, maybe the most important period of your life. So you could write lots of wonderful academic monographs, you could make a lot of money, you could do all sorts of things. But I think looking back at what we did, I think that for me personally, those 10 years were really well spent. And these are now the final months of my presidency. I'm delighted to see that the ELI will be in really good hands after September. What Pascal, modest as he always is, didn't really mention is that he will soon be the president of the ELI, and John will continue as first vice president. So I know that the ELI is in very good hands also after September 2021, in much better hands probably. So this is something that makes me be really optimistic that the next 10 years will be at least as good, but probably much better than the 10 years that are lying behind us. So thank you so much to all of you, and I wish you a pleasant evening and us all a wonderful and very fruitful next decade of ELI work. Thank you very much and goodbye.